I now request all the guests to proceed towards the stage for lighting the lamp, which is a very important tradition of our soil. This lighting of lamp symbolizes that we are beginning the journey from darkness to enlightened wisdom. It is indeed our honor and privilege to have such tall personalities on stage for this very auspicious occasion. I request all the dignitaries to please take the chairs. A big round of applause, everyone, for our esteemed dignitaries here. Thank you. Ladies and gentlemen, distinguished guests, and esteemed participants, welcome to the grand stage of 4th International Symposium on Law and Peace, ISLP, organized by Dr. Vishwanath Karad, MIT World Peace University, Pune, Bharat. I am Professor Shubhi Trivedi, the anchor for today's momentous occasion. We have gathered here to share a vision to illuminate the path of peace and harmony through the lens of law. ISLP aspires to be the shining beacon bringing together the legal professionals, policy makers, thinkers, and members of the global society at large. It is a platform where we not only address the conflict resolution, but also actively engage in peace-building processes. I would like to request each one of you to rise in your seats for a very special prayer, the World Peace Prayer. It is a prayer that does not talk about any caste, creed, religion, or a particular section of society. This prayer is to the Almighty for the well-being of entire humanity. I request all of you to join your hands, close your eyes, and wholeheartedly participate in the World Peace Prayer.
वेद प्रतिपाद्या जय जय स्वसंवेद्या आत्मरूपा देवातुति गणेषु सकलार्थमतिप्रकाशु म्हणे निवृत्तिदासु अवधारि गोदी गुरुर्ब्रह्मा गुरुर्विष्णु गुरुर्देवो महेश्वरः गुरुः साक्षात् परब्रह्मा तस्मै श्री गुरवे नमः। पूर्णमदः पूर्णमिदं पूर्णात् पूर्णमुदच्यते पूर्णस्य पूर्णमादाय पूर्णमेवावशिष्यते ॐ शान्ति शान्ति शान्तिः.
Thank you. Now we will have our national song, Vande Mataram. I request the technical team to play the national song.
Vande Mataram, Vande Mataram, Sujalam Sufalam, Malayaj Sheetalam, Shasya Shamalam Mataram, Vande Mataram. Shubhra-jyosna pulakitayaminim Pullakusumita drumadala shobhinim Suhasinim Sumadhura bhashinim Sukhadam varadam mataram Vande Mataram Vande Mataram.
Thank you very much, everyone. Please take your seats. The 4th International Symposium on Law and Peace aims to become one of the brightest beacons to herald peace and harmony through the lens of law. ISLP strives to provide a common platform to legal professionals, policy planners, thinkers, and global society at large, where they can come together for dialogue, open discussions, deliberations, and use the platform to recommend measures to address conflict resolution through peace-building process, to promote the culture of peace and harmony for the dynamic and complex society. The symposium is a unique platform for non-political and non-aligned deliberations between judges, lawyers, jurists, adjudicators, legal advisors, mediators, academicians, policymakers, social observers, industry personnel, youth, and society at large to meet, exchange perspectives, and share best practices relating to the promotion of ethical and spirited leadership and for promoting sustainable peace and development processes through law and justice. I request the technical team to relay a concept film on ISLP.
The path towards attainment of peace is always full of hurdles. However, legal deliberations can act as an important scaffolding for the construction of a peaceful culture. The legal fraternity is envisioned to be the harbinger of hope that will lead human beings towards harmony. Law indeed is the means to attain the ultimate goal of peace through amicable dispute settlement, and therefore this international symposium has been incepted to herald law to promote peace. This international symposium on law and peace, ISLP, which is organized by MIT World Peace University School of Law, aims to become one of the brightest beacons to herald peace and harmony through the lens of law. The ISLP strives to provide a common platform to legal professionals, youths, policy planners, thinkers, and global society at large, where they can come together for the dialogue, open discussions, deliberations, and can use the platform to recommend measures to address conflict resolution through peace-building processes, to promote the culture of peace and harmony for digitally dynamic and complex society. The main mission of arranging Symposium on Law and Peace is to promote peace and harmony in global society through lawmaking processes and policy decisions by imbibing the principles of justice, equity, and good conscience. Sensitizing budding legal professionals as conflict resolution ambassadors to initiate dialogue between lawyers, judges, policymakers, jurists, academicians, youth, society, and industry about legal dimensions and peace perspectives. Law is there for us when we are there with law. Let's make the best out of this golden opportunity. Welcome to this International Symposium on Law and Peace.
A big round of applause for this very beautiful concept of ISLP, ladies and gentlemen. And now, I would like to welcome Honorable Vice Chancellor of MIT World Peace University, Dr. R.M. Chitnis, sir, for his welcome address. A big
Good morning to all of you. This is a very special occasion. That is the inauguration ceremony of the International Symposium on Law and Peace. Today, we have gathered under a fascinating theme, that is legal system, the foundation for world peace. A topic that is not only timely but deeply consequential for the world we envision for our future generations like you. On behalf of our founder president, revered Honorable Dr. Vishwanath Karad sir, on behalf of Honorable Executive President Dr. Rahul Vishwanath Karad sir, and all the senior members of MIT Group, may we extend a warm welcome to Honorable Justice G.A. Asanam sir of Bombay High Court, Honorable Dr. Sudhakar Awad sir, eminent pleader, senior advocate, and also the third guest, Advocate Sangram Desai, who is on the way from Mumbai and stuck up in Lonavala right now, could be reaching here by 11:15 to 11:30. Advocate Sangram Desai is Honorable Chairman of the Bar Council of Maharashtra and Goa. And also welcome all other distinguished leaders and dignitaries present here today. And I also extend a warm welcome to all faculty members, students of School of Law. Friends, 40 years ago, our founder president, Dr. Vishwanath Karad sir, who had an earnest urge in his mind and fire in his belly to lit the pyre of value-based education, created MIT Group. And this glorious legacy is successfully carried forward by Honorable Dr. Rahul Vishwanath Karad sir through unique and innovative social initiatives, such as Social Leadership Development Program, Rural Immersion Program, co-creation activities in association with University of Amsterdam, national and international academic immersion programs, research, innovation, design, and entrepreneurship, that is the RIDE program, Bharatiya Chhatra Sansad, about which I will speak at the end, Sarpanch Sansad, UPSC Toppers Felicitation, Experience of National Defense Academy, National Legislators Conference, and so on. The concept of world peace is one that has captivated human imagination for centuries. Yet, history reminds us that achieving and sustaining peace is neither spontaneous nor accidental. It requires deliberate efforts, institutional frameworks, and unwavering commitment to justice. At the heart of these efforts of peace lies the legal system, a cornerstone of civilized society. The legal system doesn't merely resolve disputes or establish order. It defines the very principles of equity, fairness, mutual respect. Essentially, the rule of law is the glue that holds the promise of peace together. However, as we reflect on this theme, we must also confront pressing questions. How do we ensure a legal system adapt to the realities of the interconnected and rapidly changing world? How can we address disparities in access to justice, ensuring that the vulnerable and not left behind? And the third, and perhaps the most critically, how can we foster global cooperation to strengthen international legal norms in an era of rising tensions and competing interests in this world? This symposium serves a platform to explore these questions and more. The presence of distinguished legal minds and thought leaders here today reflect a shared commitment to addressing these challenges with wisdom and with innovation. It is my hope that our discussions will not only illuminate the pathways to a more just world, a peaceful world, but also inspire actionable steps toward realizing it. Let's remember that peace is not merely the absence of conflict, but it is presence of justice, presence of equality, presence of dignity. By strengthening legal systems at local, national, and international levels, we create the foundation upon which this vision of peace can stand firm. May I once again warmly welcome all the dignitaries and participants of ISLP, and allow me some time to declare about Bharatiya Chhatra Sansad, a unique social initiative, a largest platform in the world of educated young students or the youth or the new generation like you, created by visionary Dr. Rahul Vishwanath Karad sir, who is also alma mater of Harvard Business School. He said that MIT School of Government will be one of the unique schools started in 2005 in association with Sri Seshanji, then election commissioner. But then in 2011, sir realized that we give access to MIT School of Governments of only 60 students. And our country has more than 50 to 60 crore youth, and created Bharatiya Chhatra Sansad, where students come and interact and try to foster the democracy, increase or the strengthen the fabric of democracy, and students directly interact with who's who in the political, bureaucracy, legal systems, and media, which are the four pillars of our democracy, the largest democracy in the world after America. And there where your role comes as this particular event, Bharatiya Chhatra Sansad, as envisaged by Honorable Dr. Rahul Vishwanath Karad sir, to be driven by students, for the students, by the students, and for the entire country. The dates will be 8th, 9th, and 10th of February 2025. You have enough time to dwell upon. The format will be morning, you will have inauguration, afternoon there will be like ride, students' participation, democracy, or to be depicted on the stage with a different kind of a states which we have. And what was done in NLC, and which was very favorite of that particular set of MLAs, is ramp of democracy, dance of democracy, as rightly said by Honorable Dr. Rahul Karad sir. You will be participating with a different kind of a political satire, or it could be any presentation you want to do, and your aspirations also can be depicted through your performances. Second day, again morning 2 sessions, afternoon you will be having Youth to Youth Connect, and that is in association with VU University Amsterdam, where students will be going into different 100 classrooms, and all the MLAs will be coming and talking to you. And after that, third day, there will be morning 1 session and valedictory, but after lunch on the third day, after valedictory, another innovative program Dr. Rahul Karad sir is bringing. It could be either Kumar Vishwas, his program, or it could be some other program which we have not yet finalized. This university is yours. This Bharatiya Chhatra Sansad is yours. You have to drive it. All the faculties will be guiding force. With this word, I request you to register for Bharatiya Chhatra Sansad, and once again welcome all the dignitaries on the dais Thank you, Dr. Awad sir and Dr. Sandap sir, for giving your valuable time. Jai Hind, Jai Bharat, Vande Mataram. Best wishes to all of you for next 2 days.
Thank you so much, sir, for your inspiring words. Now, as per the tradition of our country and this platform, I would like to request Honorable Founder, revered Professor Dr. Vishwanath D. Karad, sir, who is the founder and chief patron of Myers MIT Group of Institutions. Sir is also the UNESCO chairholder and president of MIT World Peace University, Pune, as well as the creator of one of the biggest dome of the world, the World Peace Dome, Pune, to felicitate the chief guest, Honorable Justice G.A. Sanup, Judge, Bombay High Court. Thank you, sir. I would now like to request Honorable Managing Trustee and Executive President, Myers Group of Institution, Dr. Rahul V. Karad, sir, to felicitate our special guest of honor, Advocate Dr. Sudhakar Abhar, sir. May I have a big round of applause, everyone? Thank you, sir. It is our privilege to have with us Honorable Managing Trustee and Executive President of Myers MIT Group of Institutions, Dr. Rahul V. Karad, sir. Sir is also the Executive President of MIT World Peace University, Pune. As we are aware, sir is also the Chief Initiator of MIT School of Government, First School of Bharat for Political Leadership, as well as the founder of National Legislators Conference Bharat, Bharatiya Chhatra Sansad, National Teachers Congress, National Women's Parliament, Rashtriya Sarpanch Sansad. Thank you, sir, for providing us so many platforms. I request our technical team to please relay a video on First National Legislators Conference. Thank you.
thing you desire for the welfare of a person, this constitution paves a way for you to achieve your goal.
I would like to take this privilege to thank you, sir, for providing us this wonderful platform where, for the first time in the history of independent Bharat, an exclusive platform was created for the legislators, that is, MLAs and MLCs, who are the lawmakers of our country, came together with the vision of Shri Rahul V. Karad, sir. It is the first historic conference of national legislators which convened in Mumbai last year, where about 1,800 legislators across all political parties and from all states of India gathered and extensively deliberated over the issues and challenges related to democracy, governance, development, and opportunities of collaboration. Thank you, sir. A big round of applause for sir.
I'll just take a minute. The most respected Honorable Justice Sanab Sahab, thank you so much for your time, sir. Our very, well associated with this very institution, Sudhakar Awardji, very senior lawyer from city of Pune, and our revered founder, Dr. Vishwanath Karad, sir, our Vice Chancellor, Madam Inamdar. Great efforts, all the teachers sitting here, and my dear fellow students. The very film what you saw just now, I just wanted to connect little, the why this, particularly the National Legislators Conference. And next 2 days, from today this is the inauguration ceremony, the lawmakers and the lawyers, I think, and the policy makers. We have a public school also, we have a school of government also, we have a school of law also. So the idea is that how you guys can take the full benefit, because I see this particular effort as a laboratory for all of you to learn. And naturally, you all know what I'm saying. And in the month of February, as our Vice Chancellor just now said, that we have a Students' Parliament, the first such platform in the country to develop the future politicians, Indian Students' Parliament, the only such platform nationally which is supported by Government of India also. And we are just saying that educated youth must come in public life, qualified, competent people have to come in public life, and let us transform this nation. Very simple, we want qualified, competent, good people in our polity of our country. And of course, all these efforts here, we have School of Journalism, School of Public Policy, School of Government, School of Law, and School of Economics. I think you guys have a very important role working together, and we are trying to create an interdisciplinary culture, not just an interdisciplinary culture, but a transdisciplinary culture, Sudhakar Award, sir. Very beautifully, how do we, because societal problem solving attitude, how do we develop? The lawyers or the engineers or any such part of education you can. Ultimately, what is the purpose, Honorable Justice, sir, that to how and what way we can resolve the problems of the society. And that's how our beloved founder's vision, the unification of science and spirituality alone can bring peace to mankind. And the legal system, the foundation for the world peace. So it is not just a fashion, my dear students. You all have to really think, this is a very deep-rooted meaning, and what all things are happening, such a large population, 140 crore population, the biggest democracy in the world, and we are talking about the world peace, that ultimate order for all of us to live, and create that beautiful environment. And the law is one of the important medium, I think, for all of us, not today, but from ages. So please take the full benefit. In the month of February, please participate in the Students' Parliament. There is some design they have created. And of course, there are 300 MLAs, they are going to come for this convention, just for your knowledge. And our idea is that particularly School of Law and School of Public Policy students, you all will be getting opportunity to do the internship with all these lawmakers. They are all qualified, competent MLAs. Some 1,000 member of parliaments and 4,500 MLAs, serving this country, and they are creating laws for all of us. and we have chosen very selected 300, the MLAs and MLCs who are going to participate in this coming edition of Students' Parliament. So it is a great opportunity for all of you. Please take the full benefit and see that, as you pass out, you come out with a great colors and really make an impact in the society. Thank you so much once again, Dr. Inamdar, for giving me the opportunity. And we take this very mission of our law school beautifully ahead. Thank you so much, Justice Sanap, sir. I bow down to you. You have done a great work. 26/11 attack and further. There were no judges coming forward. Just now, Sudhakarji just shared the story. And he was one such leader. He said, it's okay. You can see there is a security given by the government of India and his contribution and his courage. Sir, we salute you for your courage and conviction for all of us. Thank you, Sanap sir.
Thank you so much, sir, for your motivating words. We have with us Advocate Dr. Sudhakar Avhad, sir, as a special guest of honor today, who would like to address this August gathering. I request you, sir, to please address the gathering. Thank you.
Good morning to all. Honorable Justice Sanap sir, who has traveled all the way from Nagpur to Pune during night time at this age. I thank him for attending this symposium. Honorable Dr. Karad sir, Honorable Dr. Rahul Karad sir, Dr. Chitnis, dignitaries on the dais, and dignitaries of the dais, and my dear students. I really congratulate this institute for arranging this symposium. I was very amused to see that it is International Symposium on Law and Peace. Friends, this reminds me of great legendary and great book writer in law, Juris Bentham. He is teacher of the teachers and the great writer of all time. He has said in his book, In the Law in the Changing Society, that what is the purpose of law? Why for law is enacted in the society? And he says that the basic function of law is to promote and to provide mutual security and mutual benefit. And that mutual security leads to the peace that is the motto and object of today's symposium. I really congratulate this institute for putting such topic for discussion for 2 days. Really, this all starts, friends, not with international declarations and United Nations organizations, etc., but its very foundation is to be found in this, our soil itself, in Indian soil itself, by promulgating, by accepting, by adopting, and by enacting the Indian Constitution on 26th November 1949. In fact, all of us can assemble here, all of us can talk here, and we can participate here and express our views, not because of international documents, not because of all other laws of the parliament, but because of the Holy Book of India, and that the Holy Book of India, the secular book of India, is the Constitution of India. And friends, therefore, this year we have completed, or we will be completing on this 26th November, 75 years of commencement of the Constitution of India. In Marathi, that is called as Amrut Mahotsavi Varsha. And therefore, throughout India, this is being celebrated by the Bar Council of India and Bar Council of Maharashtra and Goa in our state as the 75th year of commencement of the Constitution. This holy book has conferred on us these various rights because of which we can talk, we can live, we can speak, we can express ourselves. Friends, therefore, I really congratulate Dr. Rahul Karad sir and this institute for arranging such a symposium and giving me opportunity to deliver a lecture in the coming session. I'll be immediately after this session, I'll be talking on the making of the Constitution of India. Friends, we read Constitution, we have read the Constitution, all the teachers, they have read the Constitution, they are teaching the Constitution, But friends, today, I will not be talking to you regarding the Constitution of India as to its contents, but I will share with you how for 202 years, 11 days, 11 months and 18 days, those 299 members of the Constituent Assembly, great towering personalities, 75 barristers and 250 lawyers, they participated together and then thereby they created this Constitution of India that can be called as Amrut Kumbha. And because of that Amrut Kumbha or Constitution of India, we all are safe in this land, and in the world, we are looked upon as the largest democracy. This document, how it has been made, what is the process adopted by the Constituent Assembly in making of this Constitution, I'll be telling you and sharing you very such nice things in the second session. Especially I will tell you, how many of you know that in the Constitution of India, there is a picture of Lord Sri Krishna, there is a picture of Sri Ram Prabhu. How many of you know that in the Constitution of India, there is a picture of Shivaji Maharaj, Chhatrapati Shivaji Maharaj? How many of you know that in this Constitution, there is a picture of Himalayas and the desert of Rajasthan? This is all in our Constitution. How this Constitution has been made, I'll be sharing with you one very interesting aspect in the second session, that the writer means the clerk who wrote this Constitution, as per the instructions of Dr. Babasaheb Ambedkar, he has put a condition to great Jawaharlal Nehru, the first Prime Minister of India, that, sir, I will write this, I'll be your clerk, subject to, I will sign on each page of the Constitution of India. On each page of the Constitution of India, nobody has signed. Not even Dr. Rajendra Prasad has signed. Only one person, a common man, has signed on each page of the Constitution of India. All those niceties of making of the Constitution, process of the making of the Constitution, I will be sharing in the second session or the session hereafter available for me. Friends, at this beginning, I give my all best wishes to this symposium, and also the best wishes to this institute and to all of you to participate in this symposium. I thank the institute, and especially I must thank this lady, because friends, today I was really busy and occupied with my all other works. I am already busy with my works and various commitments, but she persuaded me by giving me a special message from Rahul Karar sir to cancel my all programs and to be here for this morning. I thank her specially. Thank you very much. Dr. Inamdar madam, I thank her for this occasion. Thank you very much.
Thank you so much, sir, for your words. We look forward for your enriching session.
I just want to communicate to all the students about awards, sir. I'm sure you all know that there are hundreds of law colleges in the state of Maharashtra, and nationally also so many colleges, but not to just to praise him. He's associated with this institution last 35, 40 years from his, the founding of this institution. But another important aspect which is relevant to your field is, among those, we can consider him among those top 5 important teachers in the state of Maharashtra, he has coached thousands of lawyers in the state of Maharashtra, I mean the budding lawyers, and they all are now in the various important positions in the state of Maharashtra and nationally also. So we must clap once again to Advocate Sudhakar Sahab for his contribution. Thank you, and you are going to be very lucky to hear him in the next session. Thank you, sir. Thank you.
Thank you, sir, and we greatly look forward towards your next session. Thank you. We have with us Honorable Justice G.A. Sanap, Judge, Bombay High Court, for addressing today's gathering. I request the technical team to play a short video about sir.
Advocate Sangram D. Desai is a distinguished legal professional known for his expertise in various serving as a judge of the Bombay High Court. He is known for his significant contributions to the legal landscape of Maharashtra and the broad. Justice G.A. Sanap is a respected judge in the judiciary of India, currently serving as a judge of the Bombay High Court. He is known for his significant contributions to the legal landscape of Maharashtra and the broader Indian legal system. Justice Sanap was appointed to the Bombay High Court in 2019. and has since earned a reputation for his thorough legal knowledge, impartiality, and clarity in judgments. His judicial career spans various important matters, including constitutional law, criminal law, and civil cases, where his decisions have often set precedents in legal interpretations. In 2011, he was appointed as a presiding officer of Special TADA Court for conducting 1993 Mumbai serial bomb blast cases and other cases under TADA-P Act in 2017, completed the trial and delivered judgment in 1993 Mumbai serial bomb blast case. Before being elevated as a judge of the Bombay High Court, he was posted as a president of Maharashtra State Cooperative Appellate Court, Mumbai. He was elevated as an additional judge of the Bombay High Court on 25 June 2021. Justice Sanap's judgments are characterized by meticulous reasoning and an empathetic understanding of societal issues. He has been lauded for his ability to balance.
Sir, to address the gathering, a very big round of applause, ladies and gentlemen, for Justice Sana.
A very good morning to all. Respected Dr. Vishwanath Karat, the founder and the mentor of MIT. Respected the teacher and a jurist, Dr. Sudhakarji Award, a young, energetic and the man with a vision for the sustainable development of the society, law and everything around us, Dr. Rahul Karat, Dr. Inamdar Madam, other dignitaries on the dais, and the most important, my young brothers and sisters, students. This is the third time that Dr. Rahul Karat chased me. On the last two occasions, I could not make it to come and share my thoughts, my views, and interact with student friends. This time, when I received the invitation, I made it clear to myself that this time I would not miss this opportunity and thereby deny this opportunity to all my student friends. The contribution of respected Dr. Vishwanath Karat in the field of education is commendable. I don't know whether you know that how he has started, from where he has started. When I last time visited his campus at Loni, I had an interaction with him, and he told me the family background, the circumstances, and the situation very grave. He is from a farmer's family, I believe. See the empire established by a man who hails from a small village. How it is possible? We should ponder over it. How it is possible, how he should have made it possible. One can imagine his vision and the hard work he put in for making all these facilities, state-of-the-art facilities available for the students. I have visited so many institutions, but I'm not flattering, I'm not exaggerating, but when I entered these premises, I found a real touch of humanity, a real touch of a great thinker for the society, and above all, a touch of spirituality. It is very hard to find nowadays. So, sir, we appreciate your society, service to the society. It is commendable. You need not worry, because the worry of every father who has achieved such a success is that how to carry this flag forward. You are a torch bearer, someone as capable as you, as visionary as you, must be there to follow in your footsteps and carry the said torch, which has so far eliminated the society, poor sections of the society, and everybody who has a part of the society and associated with him. Rahul Karad, I may say that that you had a big responsibility, because whenever the work of the son of a successful father is considered, it is always appreciated, keeping in mind the man who is the father of that man. So you are always compared in all respects with your father, and here, before this august gathering, I must tell you that he has been putting his right foot forward and has matched so far the strides with the great Vishwanathji Karad, so he deserves a round applause. We have seen the video clip of the organization of the seminar or a conference of all the legislators in India. It was not a simple task. It was a mammoth task by any sense. Apart from money, it required a meticulous management, meticulous preparation. Without a meticulous management with a proper vision, it is very difficult to make such a program or function successful. My association with the award family goes back to 1989. I must share with you my background, because if I don't share with you, then it may not inspire some of you who are similar in a position in which I had been when I studied the law. I proudly tell wherever I go that I am from farmers' family, a judge, High Court judge from farmers' family. My parents were illiterate. When I took my first stride, it was on the field. I believe that in those days, there were no facilities of the crèche, etc., even in villages. The women folk in the villages would carry the children with them for doing all the labor work on the field. I deem myself very fortunate that I grew in the company of nature, animals, and the parents who were not educated but committed to the job. As a farmer, some may agree with me, that the farmer never thinks of the profit. And even for the farmer, forget about the profit, that the investment he has put in, the return of that investment is not assured. So, the farmer does a hard work without bothering about the return of the hard work. And I studied in a primary Jilla Parishad school. So, with every sphere of education or every stage of education, first I was a farmer, then a student. First I was a farmer, then a primary student. First I was a farmer, then the student of the degree course. First farmer, and then the student of law. So I learned the importance of the hard work from my parents, my villagers, with the committed, dedicated hard work. I succeeded in my life. I could succeed in my life. Money may not be that important. What is important is your dedication, commitment, your earnest desire to achieve the success. I must tell you, sir, when I got married, I started my life with 100 rupees. And even while practicing law, I kept the mantra of my father, my family, that if you want to climb the ladder and to reach any position, there is no substitute for hard work. So please, my friends, remember, you are in a profession which is very demanding. First, you have to establish your caliber, capacity to get recognition in the profession. I may address you on the requirements of the profession, the requirements to go to the top in the profession. First, coming back to this the subject, peace and the law, or rather rule of law. When we talk about peace, I am encroaching on your time, Mr. Desai. Ah. So you can't make a grievance now, sir. You have taken 10 minutes more, because I have filled the vacuum which was created by your absence. It is our duty as a citizen of this country to strive for peace. The concept of peace has to be understood. The concept of peace of a citizen should not be self-centered or self-centric. Most of the time, we see in the society that it is self-centered and self-centric, in the sense that we worry and take care of our own peace, peace of our family, peace of our loved ones. In my view, this is not a real concept of a peace. The concept of a peace must be from the perspective of the society, from the perspective of a country, from the perspective of the global community. Unless and until we broaden a version of the peace in this manner, it is not going to serve any purpose in the longer run. In a world that is increasingly interconnected yet fraught with conflict, the role of law as a tool for peace cannot be overstated. Law provides the framework within which societies can resolve disputes, protect human rights, and promote justice. When I said that that is the horizon of this concept of a peace should be enlarged, that we have to look into all these, we have to keep all these things in mind. This symposium is a testament to our collective commitment to these ideals. Over the next few days, you will explore a wide range of topics, from the changing dimensions of legal education to the critical issues of gender justice and human rights. You will examine the legal reforms necessary to address the challenges of 21st century and discuss innovative approaches to conflict resolution and peace building. As we embark on this journey, let us remember that peace is not merely the absence of a conflict, but the presence of justice, equity, respect for human dignity. It is our responsibility as a legal professionals, scholars, advocates to ensure fold principles. It's the theme of this the law and peace. The relation this is the very foundation of the existence and survival of our system. The rule of law, we have to understand as and this concept of a rule of law and a due process of law, and ponder over it how this concept society. The rule principle that ensures all individuals and institutions are accountable to laws that are publicly promulgated, equally enforced and independently adjudicated. It is the bedrock of fair and just society. The rule of law guarantees that no one is above the law and that everyone is treated equally under it. This principle is essential for maintaining peace and order in society. When laws are applied consistently and fairly, it fosters trust and respect among citizens, reducing conflicts and promoting social harmony. Now, this is about the rule of law in the context of peace. Now, due process. Due process of law is fundamental aspect of the rule of law. It ensures that the legal proceedings are conducted fairly and that individuals' rights are protected throughout the judicial process. Due process includes the right to a fair trial, the right to be heard, and the right to impartial tribunal. These protections are crucial for preventing abuses of the power and ensuring that justice is served. By upholding due process, we reinforce the legitimacy of our legal system and promote peace by providing a mechanism for resolving disputes without resorting to violence. Now, in the above context, through the above lens, we have to consider the law and peace. The connection between law and peace is profound. Laws provide a framework for resolving conflicts and protecting rights, which are essential for maintaining social order. When laws are just and applied fairly, they help to prevent grievances that can lead to unrest and violence. Moreover, the rule of law and a due process create an environment where individuals feel secure in their rights and confident that justice will be served. This essence of the security, so please mind this sentence, that this sense of a security is a cornerstone of peace. Now, you may deliberate upon the challenges which you would be facing in your future life as a lawyer, as a citizen, and what is the way forward in this context. Despite the importance of the rule of law and due process, challenges remain. Corruption, discrimination, and unequal access to justice can undermine these principles and threaten peace. It is our collective responsibility to address these issues and strengthen our legal institutions. We must ensure that the laws are just, they are applied impartially, and that everyone has access to legal remedies. By doing so, we can build a more peaceful and just society, which is the theme of today's this symposium. Now, with your further permission, I may address the students for 5 minutes. We have a 5 minutes time, no? I have collected the information about the courses which are imparted in this university. The education up to master's degree in law is imparted through this university. You are lucky and fortunate that you are part and associated with this august institution, which is managed and run by a visionary. I am told that after examination, the last batch would apply for sanad to practice as a lawyer. Friends, your journey as a lawyer or the life as a lawyer would start in a real sense the day you get the sanad to practice the law. All may not go to the practice. Some of you may go to the litigation practice. Some of you may go to corporate offices, means non-litigation branch. Some of you may become judges, and some of you may become academicians. Wherever you go, as long as you are alive, you will be the student of the law. The day you stop studying the law, you will be, your existence will be meaningless for not only for you but for the society. There are great challenges when you have taken education in such institutions. Your expectations are bound to be high. You may be looking for the package or packages. Nothing wrong. Please bear in mind, when you aspire to get a package, you yourself must be a package for the one who wants to avail your services. For that purpose, if you decide to go to practice litigation, first you have to think over the problems there, procedural problems, go to a senior's office and follow the proceedings. As far as the law is concerned, legal practice is concerned, there is a saying that in the life of the lawyer there are three stages. First, No work, no money. It depends how long you continue with this no work, no money phase. It depends upon your hard work. It depends upon your approach to your life, to your profession. The second phase in the life of the advocate is only work, no money, or less money. Only work, less money. When this phase comes to your life, in your life, you must grab that opportunity of doing work by both the hands, and you must establish yourself as a package in that profession. You must be in a demand. And the third and most important phase, and there is a rider. This third phase in your life would come provided you are fully focused, fully committed, work with full dedication during the first two phases. The third phase is only money and minimum work. Now, friends, it is up to you. And from my own experience, that is why I have shared my experience with you. You can dream high, but the only thing that you will have to keep in mind that always you must put a right foot forward to achieve your dream. Nowadays, technology is at your fingertip. During the old days, we were fortunate. I don't know how many of you are reading a commentary from Mullah's book, Hindu Law, IPC, CRPC. We had no facility of this finding case laws, finding any material. And to get one case law on a particular subject, we would be required to read the commentary from 4-5 textbooks. And that is why we could develop concepts of the law and clarity about the law, which helped me, helped Awad sir. He is a teacher of teachers. You go to any nook and corner of, I think, Maharashtra and the India, you will find his students there as advocates, judges, and academicians. So, friends, if you want to achieve an extraordinary feat, think how can you achieve? Ask a question to yourself whether you can achieve the extraordinary feat with an ordinary efforts. And if your efforts are extraordinary, no one can stop you from reaching the top with the flying colors. My best wishes are with you. I am grateful to Dr. Vishwanath Ji Karad, Dr. Rahul Karad, and more particularly I am grateful to jurist for me and teacher for me, Awad sir, because he has spared his valuable time for today's function. Sangram Desai has come now. We are from the legal fraternity. So students, be focused. The path which you have to tread is not as simple as it has been so far. You will be treading a very difficult path in your life, full of obstacles, hurdles. Don't get discouraged. Whenever you face any problem, try to find out an answer. And my sincere advice to you, if possible, curtail your time on this idiot box called mobile. Make a friendship with books. Read the commentaries from the books. Unless and until you read, you will not master the art as a lawyer, as an academician, or as a corporate lawyer, or even as a judge. Once again, thank you. Thank you so much.
Thank you so much, sir. I request everyone to please stand for a standing ovation for sir.
Thank you, Your Lordship, for sharing your experiences and knowledge. We are really obliged. Once again, thank you very much.
As we proceed ahead, we have with us Advocate Sangram Desai, sir, to grace today's occasion. I would request the technical team to play a short video on sir. Thank you.
Advocate Sangram D. Desai is a distinguished legal professional known for his expertise in various branches of law, including civil, criminal, and corporate law. With over 2 decades of experience in the legal field, Advocate Desai has established a reputation for his dedication to his clients and his deep understanding of complex legal matters. He is known for his strategic approach to litigation, offering practical solutions to both individuals and businesses. Advocate Desai graduated in law from Shahaji Law College at Kolhapur, Shivaji University, BSL LLB in year 1996. He has appeared and conducted thousands of criminal cases and session trial in Sindhudurg, Ratnagiri, Mumbai, Kolhapur, State of Goa, Chhattisgarh, and Karnataka. He was highly appreciated for his work in judgment by the Honorable Judge in the famous Nando's murder trial. In addition to his work as a practicing lawyer, Advocate Desai is a well-respected legal educator and mentor. He frequently conducts workshops and seminars to educate the next generation of legal professionals and is a sought-after speaker at various legal forums. Known for his integrity, professionalism, and commitment to justice, Advocate Sangram D. Desai continues to make a significant impact in the legal community. His work is characterized by a thorough understanding of the law, a client-centered approach, and an unwavering commitment to excellence. We warmly welcome Advocate Sangram D. Desai. D. Desai.
I would like to request Honorable Vice Chancellor of MIT World Peace University, Dr. R.M. Chitnis, sir, to felicitate our special guest of honor, Advocate Sangram Desai, sir. A big round of applause, everyone. Thank you, sir. And now it is my honor to invite Advocate Sangram Desai, sir, to address this august gathering.
Friends, this is not usual to intervene, but before Advocate Sangram Desai addresses you, I must speak few words about him, because this galaxy of the attendants today may not be knowing about him. He is the youngest chairman of the Bar Council of Maharashtra and Goa. Our council in Maharashtra is having its membership of 250,000 lawyers. Of these 250,000 lawyers, he is the chairman, youngest chairman of the Bar Council. Secondly, all the legal fraternity in Maharashtra, including myself, we owe him a lot because very recently he has acquired from Maharashtra, government of Maharashtra, 2 acres of land for Advocates Academy in New Bombay, and very recently this was inaugurated at the hands of Judge of the Supreme Court of India. So he is the person, he is the towering personality who has contributed towards establishing Lawyers and Advocates Academy at New Bombay and also Lawyers Advocates Bhavan at New Mumbai. All credit goes to him. I have experienced, friends, that this government machinery moves so slowly at snail's pace. But when this academy was to be established, on one phone call from Justice Gawai at his behest, entire Maharashtra government machinery started, and within one day, land was allotted, 712 was made, 712 was made. Within one day, land was allotted, and within one day, Mr. Fadnavis, the Deputy CM of Maharashtra in that function, he allocated 10 crores initial fund for the academy. Government of Maharashtra, at his instance, allocated 100 crore rupees funds for our academy, and that is being constructed at the hands of this gentleman. Therefore, friends, let us applaud him for his contributions. Thank you very much.
Thank you, sir, for introducing Advocate Sangram Desai, sir, so beautifully to our students. May I please request, sir, for the address.
Good morning, all my dear friends. To start with, I should first of all say sorry to all of you getting late. But frankly speaking, we are having many functions on the account of 75 years the adopting of the Constitution of India. The Bar Council is holding so many functions. So yesterday I was in Goa, then I came back to Sindhudurg, then I traveled to Bombay, and from Bombay I came to Pune, because at any cost I wanted to attend this function, and it's like a great opportunity for me. So the Honorable Chief Guest of this function, my Lord Justice Sanap Sir, Honorable Shri Rahul Karadji, Honorable Shri Vishwanath Karadji, Dr. R.M. Chitnis, the Vice Chancellor, Dr. Purnima Inamdar Madam, the Associate Dean, Dr. Abhijit Dere, the Program Director, and above all, who just introduced me, the great and the towering personality, Awad Sir, who is a guru to me. Sir, tumhala atishay manapasna namaskar. Now, before I came, yesterday evening, it was such a pleasant surprise that I received a phone call. And that phone call, I come from Sindhudurg district, the name of the place where I stay. I came from is Kodal. And yesterday evening, I received a call from a young boy. And he said, Sir, तुम्ही मला ओळखलं का? मी XYZ. आता मी त्याचं नाव घेणं योग्य राहणार नाही because he's a student of this college, it seems. And then he said, म्हटलं, तू इथे काय जॉब वगैरे करतोस का? तर नाही म्हणाला, सर, मी इथे सेकंड इयरचा स्टुडंट आहे. So a guy from Sindhudurg, it's like 500 kilometers from Pune, is coming all the way and studying in this great institution. And I was so happy that the people or the young boys all across the state of Maharashtra from different corners come to such a great institution. Sir, you are doing a great work for all these great students. So I think a round of applause to the management. I was just seeing the photographs and the work done by this great institution. Yesterday, I was just searching on the internet and I could find so much about this institution. And when I was speaking with Sir just now, a few minutes back, he mentioned about the land which was given rather to this institution on which this great campus has been built. So it's an amazing work that this institution is doing. Now, it would be not good of me to be speaking too much after my Lord Justice Sanap has already spoken. But I have to make a few points. And more than anything else, it's a very nostalgic moment for me whenever I get a chance to interact with the young lawyers. So I still remember my college days when I used to be a student like you sitting across, and eminent personalities coming and delivering lectures to me. And not necessarily that everybody is always interested in these subjects, because being young and I should say volatile, we have different thoughts in our minds. We think of so many things. At a moment, we feel that I'm so much interested in my profession. At the very same time, we have to go out and meet with our friends, chat and enjoy and do some things which we want to do. So maybe sometimes sitting for 2 hours, 3 hours, listening to these lectures can become a little bit boring, right? So this is what I remember when I used to be in college, and when different lecturers used to come and they used to deliver lecture on different subjects using very difficult words, and then which we'll have to, now you have got Google, you can find out the meaning of the words. But then we used to just listen to them and then find out the meaning of those words. So it's like this when I remember those days of my college. But you are quite lucky that your institution is bringing great speakers like Justice Sanab sir. I have heard him, this is the third time I am with him. First when it was in the district court at Pune, then it was in Akola, and this is the first function, this is the third function I am here with Honorable Justice Sanab. An amazing speaker, and the thoughts he comes across with are great, and you young guys should understand these important aspects of profession. But then when I was thinking about today's theme, and I was just too busy in planning a function. Now, my dear friends, I'll take this opportunity to invite all of you, or maybe some of you who are really interested. We are holding a function in Bombay on 24th between 11:30 to 2 p.m. It's in Swaminarayan Mandir Hall, abutting to Dadar Station, Dadar East. Now we have completed, this is the 75th year of adopting of the Constitution of India, and we are celebrating the Amrut Mahotsav. And we have planned, that the Bar Council has planned to hold 75 different functions all across the state of Maharashtra, Goa, Div and Daman, so that we sensitize people about their rights which the Constitution of India has given. So this function we are holding on 24th, and I was planning, because there is another function which is coming up on 23rd in the High Court at Goa. Honorable Justice Sonak sir is going to speak, and in the function at Bombay, Honorable Justice Abhay Oak sir, Justice Sonak sir, the Advocate General, Birendra Saraf sir, so many great personalities are coming and putting across their views, and there will be a panel discussion. So when I was thinking about all these issues of this function, I suddenly realized the theme of this present function, the symposium, and it says that legal system, the foundation of world peace. So when I was reading and I was thinking about what to speak in that function, as we normally do, I just once again read the preamble of our Constitution. And I read it twice and I read it thrice, and then I realized that there is no word peace in the preamble of Constitution in that sense. So I just read it again. And then I realized that pre-independence days, post-independence, till now, we are always in the state of conflict. Somewhere there is a war going on, somewhere there is a conflict, individuals are fighting amongst themselves. So why this issue of peace was not included? But then you have to realize, as a student of laws, you will have to understand the provisions of laws or statutes in different contexts than the plain reading of any law. So I read again and again, and these 4 words, justice, liberty, equality, and fraternity, these are the 4 words in the Constitution of India, which according to me are the most important words. Now when we are thinking about this, today's subject, that is the legal system and the foundation of world peace, how is the legal system related to peace? And my Lord, Justice Sanab just made it very clear in one sentence or one line that peace is equal to rule of law, correct? So what do we mean? If there is a rule of law, definitely we are going to establish peace in a way. So therefore, then the Constitution of India, even though the word peace is not there, it says about justice, which is social, economic, and political. It says liberty of thought, expression, belief, faith, and worship. It says about equality of status and opportunity. And it says about fraternity, assuring dignity of individuals. So when we think about all these issues, what else is peace? This is there to have a rule of law. And when there is a rule of law, definitely we are at peace, or we can bring peace. And therefore, the Constitution of India has already considered this aspect, even though the words peace may not be found. But then I just did a little bit of research and tried to find out that yes, we are talking about our country, what's happening internationally. And then I would like to bring to your notice two important aspects. And this charter that established the United Nations, which was adopted way back on 26th of June 1945, and which came into force on 24th of August 1945, which was ratified time and again till 2021, in which 193 countries were parties. So now this Charter of United Nations, the preamble to this charter. Now, my dear friends, it's very important to understand nationally as well as internationally. And therefore it says, and I quote, to reaffirm the preamble to this charter expresses a determination, and I quote, to reaffirm faith in fundamental rights, in the dignities and worth of human person. Now, this is very important. In dignities and worth of human person, in equal rights of men and women and of nations, large and small. Not only is this, but Article 1 of the said charters again quotes, there are many articles, one is very important which I am quoting, and I quote, the commitments to maintain international peace and security, to promote and encourage respect for human rights and for fundamental freedoms for all, without discrimination as a race, sex, language, or religion. And that is what precisely the Constitution of India says. So right since the year 1945, or maybe before that, till today, we are again coming back to the same thing, that there has to be a rule of law. And now that there has to be a rule of law, who are the stakeholders? Of course, an individual, a citizen of a country is a stakeholder. But at the very same time, I'm coming to the most important profession, our profession. We are the major stakeholders in bringing peace nationally and internationally. We have a pivotal role to play in bringing peace. And how do we do that? Do we have a mechanism? Just because you become lawyers, you get a LLB degree, you go to the courts, you conduct matters, you do litigation. What is it? In what way are you going to help bring peace, bring rule of law? And my dear friends, I feel that we could do this in 4 steps. This is what I have understood in my own way. It's not necessarily that I'm right, but we could do it in 4 steps. And it's a very simple logic. We don't have to use these difficult words which are difficult for a common man to understand. Let's make it try and make it very simple. So when we say about the fundamental rights, we know that I have a right to do this. I have freedom of speech. I have freedom of expression. We have got so many rights, and we know all and everything about the rights. But the most important aspect is, what we are missing out is that there are so many individuals in a country who are not even recognized by the state. So the first and important task is recognition of a person's existence and his identity. Now this may sound new to you. As you come in this metro cities and study, you have your own Aadhaar card, you have your identity card, you have a driving license, you have got so many things, right? You have got so many things with you to show anybody, traffic police stops you, you say, I have got a license. If you go to a hotel, you have to stay, you have to show an Aadhaar card. If you have to go for voting, you show a voting I card. So many things of identity. But there are a class of people in the remote villages who are economically, socially backward, underprivileged, who don't even know. Their births are also not recorded. Their deaths are not recorded. If their births are recorded, they are not identified in the terms that they get an Aadhaar card. So their recognition as an individual by the state is the most important and the first step if we want to have a rule of law. Unless a human being is not recognized by the state, he cannot assert his right as a citizen of this country, or maybe a citizen of some other country. So the first and important step which we have to ensure is that there is a recognition of that individual and his status as a citizen. That is the identity of that person. Once that is done, this is the step one. When that is done, then the next important aspect which we need to consider is bringing amongst these citizens and individuals the awareness of their rights. Now you are recognized as a citizen. Fine, great. Now you are a citizen, but then what do I do? What are the rights I have? So here the role of the lawyers come into play. Like your institution has hold this function, we are trying to create awareness amongst you about all these aspects. So in a similar way, you young lawyers, you have got a lot of time at your hand. You are studying law, you are studying different subjects of law, but at the very same time, when you have spare times, you ask your institution to have these different functions in remote villages where you go and deliver lectures on different statutes and make an individual aware of his right, which the Constitution of India gives, which an individual or which a new statutes or a different statute gives a right to that person. So once you do that, we have a twofold effect. Number one, that you, by doing this, are getting used to the provisions of law. You try to understand and interpret and, in a way, connect it with a common man, the problems which a common man is facing. So therefore, the second step would be awareness of these laws. Step number 3. Now, when you make aware a person about his rights, is it only his rights? With that right comes a responsibility, a duty. Now, we are so good at knowing our rights. We are fighting all the time. I have a right to do this, I have a right to do that. Only rights, 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 and rights. And what about the duties and what about the responsibilities? So with the rights, you have also, there comes a duty, there comes a responsibility upon you as a citizen of this country. And therefore, in my view, just do not tell them their rights, but also tell them their duties. But the third and the most important thing which you have to tell them is rights, duties, and with the rights, they also have a remedy. My dear friends, here is where the lawyers come into play. When you have a right which is infringed, which is violated, then there is always a remedy in law. And you, as a students of law or as lawyers, should be knowing the remedies which are there and making aware a common man or that person or an individual the remedies which he has in law. So step 1, step 2, and step 3. Now what is step 4? Step 4, the moment you do these 3 steps, that gentleman, that individual, that person will realize that he is a victim. Has been oppressed by certain law, by an individual, by a state, by an authority, anything, you just name it, and that person will realize that I am a victim. I am a victim of this system. My rights have been violated. My rights have been infringed. So making a person realize that he is a victim is the most important thing. My dear friends, we are quite privileged. We are sitting here in the AC halls and auditoriums and listening to all these great, great personalities. But there are people, there are students, there are, these underprivileged people who do not have all these facilities, who do not even know that they have a right, who do not even know that their rights have been infringed. So therefore, they don't realize that they are victims. So making a person realize that he is a victim would be the fourth step, and that is a very important step. That leads us to the fifth step. Step number 5, once a person realizes that he is a victim, reporting about his victimization to the concerned authority would be the fifth step. And this is where you all will have to work hard. My dear friends, please try and understand. You know, a person realizes, माझ्यावरती अन्याय झालाय, माझ्यावर अत्याचार झालेला आहे, मी गरीब आहे, माझा अधिकार याने काढून घेतलाय ना, so many things that people have, they have it all here. But then reporting it to somebody, reporting it to authority is another thing. The moment you report that with authority, two things happen. Number one, a database is created that such a thing can happen, such a thing is possible, such victimization do happen. This is a database which is created. And on the basis of this database, future victimization can be prevented. So this is the very, very important aspect which you have to understand, that any person, maybe you students here, you might feel that a particular professor or the teacher or whatever is victimizing you, is not treating you properly. I'm just mentioning it. So therefore, these are small, small things of victimization which you need to report. So once that is done, two things happen. One, a database is created, and number two that happens, it opens a door for the remedies. That particular authority to whom the person reports about the victimization will have to take action against that erring person, authority, government, state, whatever it may be. And therefore, by doing this, this would be the fifth important step in order to see that there is rule of law. And the last, once it is reported, once the victimization is reported to a concerned authority, then comes the action, the remedial action. First, stop that victimization that you can get from police, that you can get from courts, that you can get from different government authorities who are always there to take action against the erring persons who commit offenses, who commit different acts, violating the rights of a person. And if that is not done, then you go to the court of law and the litigation comes. So from step number 2, 3, 4, and 5, there is a big role of you, young lawyers, students, paralegals, whatever it may be. It is your duty, it is your responsibility to do so. And therefore, my dear friends, I feel that these are the 5 steps by which we can do it. And how do you do it? Like you as young lawyers, how are you supposed to do it? My dear friends, now we have this paralegal system, the District Legal Services Authority. I mean, sir could have said more about this. District Legal Services Authority, the State Legal Services Authority, the National Legal Services Authority, they engage the services of young students like you as paralegals. And you are asked to interact with the victims. And this is where you get your training. You just learn the laws in the books of law in colleges, but you get the practical training in these works by interacting with the victims, knowing their problems, and trying to find out the solutions. This is where you develop yourself as lawyers. And therefore, I feel that empaneling yourself on the legal aid panels, empaneling yourself on the different panels of the District Legal Service Authority, you can contact the district courts and they will be more than happy to take you on the panels so that you can interact with this. And therefore, I feel by doing all this, you can help bring a rule of law. At the end of the day, we are trying to bring peace. So in conclusion, I would say, promoting rule of law and to ensure justice for all is the key to achieve peace. Having said that, like what sir said, I will just take 2 minutes because, for me, it's like a great opportunity to interact with you as young students. My dear friends, you'll be learning a lot of subjects of law, CPC, CRPC, IPC, BNS, BNSS, all, just name it and you'll have to learn different subjects of laws. But then the question here is, by learning these subjects, are you going to be a good lawyer? Sir has suggested a few things. And believe me, that is what I have been taught since my college days. And it has turned out to be true. So we'll have to follow what sir has said. But in addition to that, I would like to make two important points. My dear friends, what is law? What is law? Then you will get different definitions. Like I was trying to search the definition of peace, and there is no definition, universal definition of peace. There are different analogies given for the word peace. In a similar way, when you say what is law, it is common sense. It is codified common sense. Put that in your head very clearly. So when you learn different provisions of law, you will feel, oh, now I know CRPC, now I know Indian Penal Code, now I know the international law, now I know the Constitution of India. So it's good in books, it's good to write paper on. But when you start practicing, is it the only thing that is going to help you? No. The thing that is going to help you is the common sense. And I urge upon the management of this college to, I don't know, you have a subject psychology for the law students? No, you have logic. Yeah, I know. Yeah. So even I had this subject logic. But my dear friends, when you are studying law, please try and learn what is human psychology. And I'll just finish with a small example. And this is when I started practicing like 6-7 years, 8 years into my practice or 9 years into my practice. I was conducting a criminal, there was a new judge who came, and I was practicing in the magistrate's court. And there was a new judge who came. So whenever you start practicing in the court and you're appearing before a new judge, you don't know how that judge thinks, right? So one day what happened is that there was a case, accident case, then section 294, whatever, 304A, whatever it was. So that was an accident case where a person was driving a vehicle, somebody came across, he dashed that person died. But it was a very good case for me. I studied a lot, I had put up a good defense, that I was at a low speed, that guy came accidentally on the middle of the road, so I had no time to respond. I did apply my brakes, but then it was so quick that I could not control. And I brought so many circumstances, on record. And I was quite confident, yes, that I've done good and I'm going to get acquittal. But that case ended up in conviction. That person was convicted for the offense under section 279, 304 for having rashly and negligently driven. And I was so upset. I said, I have done everything. I have brought on record all the circumstances. I have pointed out the law. Everything is there. Then why did I get a conviction? Fine, that was okay. Then the second case came before him. It was not mine. It was some other lawyer. He again got a conviction in the accident case. Then a third person came. Third matter came. He also got a conviction. So we 6 or 7 lawyers were, not we lawyers, but the accused were convicted in accident cases. And we were like very disturbed. And then we realized that particular judge had a tendency to convict people or accused who are accused of offenses of having committed death during a course of accident, 279, 304, 304A, whatever, rash and negligent driving. So he had a tendency for whatever, maybe somebody close to him died in an accident. He had that perception. I don't know what it was. One fine day, it so happened, maybe it was 1.5 years down the line, the same judge was driving from the place where I was practicing to some other place, or he was coming from other place to the place where I was staying, that is in Sindhur district. And when he was coming, he was driving down a ghat section. A bus was going ahead, and I don't know what happened. He just went and dashed the bus from behind. So he was the driver, he was driving a vehicle, a bus was going ahead, he went from behind and dashed that particular bus. Now this is a very interesting twist. On that day, the police came there, and in usual course, the police were not knowing that he was a judge. The first thing they did, that they lodged a report of accident and registered an FIR against that judge as an accused in an accident case. Believe me, my friends, from that day onwards, there was not a single conviction in any accident case. All cases were acquitted. So therefore, you have to understand the human psychology. It's good to see the law. It's good to read the law. It's very good to interpret the law. But it is one thing to read the law. It's one thing to interpret the law. But it is totally another thing to come and practice law as a lawyer and to conduct a case. So therefore, when you are learning law, when you are studying law, please see to it that you also understand the human psychology. That is a basic thing which you are going to, deal with all throughout. And therefore, these 4 words, strength, weaknesses, opportunities, and threats. These are the 4 words you should always bear in mind. What is your strength? What is the strength of other side? What is your weakness? What is the weakness of opposite side? What are the opportunities I have? What are the opportunities the other side has? And what are the threats which I'm going to face? And what are the threats which the other side can face, which you can use to your benefit? Once you understand law, these things, law is the most simple thing which you can do. Thank you very much for giving me that opportunity, and God bless you all. Thank you.
Thank you, madam. Thank you. Desai ji, I think, covered so beautifully. My dear friends, I just tempted to speak few words that the very emphasis on psychology. I think the politicians in our society, Sudhakar sir, I want you also to comment quickly on this. I think the 3 areas which I believe in the public domain, the politicians, police, and lawyers. I think the psychology is required in marketing field also. In every field you require to become a successful for a doctor also. But I think police and the politicians, the way they understand the pulse of people, they rule the people, and the judiciary people, the lawyers, and the police, I'm saying. So very beautifully you covered, sir. Thank you so much for, it was a very meaningful engagement. I think students really liked you. I request Professor Sudhakar sir also to comment on this very aspect, what he covered it. So academically, students can be enriched.
Honorable Chairman of the Bar Council has very succinctly described the procedures in the courts and what helps the lawyers to understand. Usually we are guided by the seniors, know your law. Now friends, we are also guiding our juniors, know your judge. Because when you go to the Supreme Court, in the trial courts, friends, we get here ample time, few hours to argue, few hours to conduct the proceedings. When we go lordship in the High Court, we get at least 5-10 minutes. But friends, whenever you visit Supreme Court, you will get only few seconds to address the court. Few seconds. Entire case which is built from the trial court, which goes to the district sessions court and then to the High Court and then to the Supreme Court, you get only few seconds. Sometimes, for the Mofassil lawyers like us, our cases are dismissed and we are not even knowing that my case is dismissed. Others tell us that, go away, your case has been dismissed and disposed of. And therefore, in Supreme Court, you will find there is a proceeding called as SLP. Now, that SLP is understood by we lawyers as special luck petition. Because in 1 second or in 2 seconds, how a lawyer can put entire case of few years proceedings in 1 or 2 seconds. And therefore, it is necessary not only to know the law, but to know the judge also. And for this purpose, this psychology, of course, is very vital in this case. To conclude at this stage, as Honorable Desai sir has said, how hard it is. As Honorable Justice Sanap sir has said, how is the lawyer's life? I remind you the case of one barrister in England. A lady came to barrister and asked him, sir, I want to induct my daughter in law course. Shall I? I am very happy to see that my daughter becomes barrister or a lawyer. What is your advice? On her question, the barrister replied, and that is applicable to you all, and that's applicable to all of us also. That is why we are here. And if you want to come here, then you be guided by that barrister's advice. I quote, barrister said, "Look, lady, in our profession, there are two things. Either there are roses and then there is no bed, or there is a bed and then no roses." Means, friends, our profession is such a profession wherein you get such a glorified life, you get such a good money, but no rest like us. No rest like these people. And if you want to have the rest and rest only, then no money. And therefore, you have to choose between, if this is a career wherein you have to devote your life and time, then you'll find, friends, today in Supreme Court, my son is in Supreme Court, he's advocate on record in Supreme Court. I am not an advocate of Supreme Court. I'm a Mofassil advocate of Pune, but I visit Supreme Court. Whenever I go with my son in Supreme Court and I just sit on the last bench of the Supreme Court, you'll find, friends, people and the advocates of your age are arguing so nicely. This profession is so nice, I tell you. There are in Supreme Court at least 200 lawyers in the Supreme Court. They are earning every day not less than 50 lakhs to 1 crore rupees, that to by check. This is industry, friends. This is no more a profession. Lawyer's profession is not more a profession now. This has become an industry nowadays. And therefore, this STEAM Institute shall look upon it more than engineering and medical college. You concentrate on this law education, because these people, they will be asset to the nation in the near future. Thank you.
Thank you so much, sir, for those beautiful words and encouraging session. As we proceed forward, as we saw the vision of our Honorable Executive President, Dr. Rahul V. Karad, sir, in bringing together lawmakers for holding dialogues to address the issues of democracy and accountable government through the NLC video, it is my privilege to announce the marking of yet another momentous occasion, unveiling of the NLC Coffee Table Book. We are aware that the three wings of the government, legislature, executive, and judiciary, play a vital role in the lawmaking process. Therefore, today, for this auspicious occasion of unveiling, in the presence of the representative of the independent judiciary, Justice Sanap, I request sir and all the other dignitaries to unveil the NLC Coffee Table Book. A big round of applause, everyone. Thank you. May I have a very big round of applause, everyone. Thank you. Thank you, dignitaries. As we move ahead, it is important to remember the philosopher on whose principles and teachings the foundations of this great institution is laid, Sant Shri Dhyaneshwara. I request the technical team to play a short film on Sant Shri Dhyaneshwara.
21वीं शताब्दी में मेरी भारत माता विश्व गुरु बनने की काबिलियत रखता है. It will become a विश्व गुरु in the 21st century. उसका छोटा सा उदाहरण, छोटा सा सिंबल यहाँ बन गया है, ऐसा मेरा मानना है.
We have only two options. Either we live together or we perish together. It is in this context, this monument will stand.
We look at this magnificent dome. To me, this is not just the biggest dome in the world. To me, this is the biggest idea, the biggest message to the world.
This country has always propagated one thought, Vasudhaiva Kutumbakam, my dear friends. I must say that in the entire history after the independence since 1947, this is one of the unique steps towards the contribution of universal humanity. I appeal to the Vice President and Honorable Chief Minister to recognize this World Peace Dome as a structure of national and global importance and support to promote it in such a way that it evolves as one of the prominent tourism destinations of the world.
We should remember and respect like Professor Vishwanath Karat and millions of people like that, and remember the great service they have done. They should be remembered forever. That is also equally important for all of us. This is the message of this dome. This is the idea of the dome. This is the tallest, not only in size, but also in ideas.
Such a beautiful film on philosopher Sanshri Dhyaneshwara, World Peace Prayer Hall, and World Peace Library, World Peace Dome. Thank you. And as we move ahead, it is my humble privilege to request Honorable Founder, revered Professor Dr. Vishwanath D. Karat sir, and UNESCO Chairholder for his presidential address.
Friends, it truly fills my heart with a sense of pride and pleasure when I stand before you on this most unique occasion of the 4th International Symposium on Law and Peace. Thank you so much, Chitnis, the Vice Chancellor, Madam Namdar and their team for organizing and choosing a very possibly the most relevant subject in the today's situation. And trying to understand what should be the law or rule of law, as was said by the most learned, the men of wisdom, really speaking, not the scholars, thinkers, and philosophers alone, but having a great wisdom and understanding of the very nature of this entire world community. And we have been trying to understand from these learned people, Honorable Justice G.S. Anab Sahab, Honorable Advocate Sangram Desai ji, who is the chairman of the Maharashtra and Goa Bar Council. But chairman is not the only designation enough, but possibly the way in which he spoke and gave and made us understand what is exactly the meaning of law or rule of law and what is meant by peace. Sudhakar Awadji, who is a member of our institution, we are so proud of him that he is recognized all over India as one of the scholarly figure, a teacher of repute. Possibly, maybe how many judges you have in the state of Maharashtra? 300. Just understand. 300 judges, possibly many of them. I'm not here to praise because of their position. I'm using these words because I have my own understanding that while making and talking about the nation and the society, the world as one family, and all nations put together have a global society. And we are trying to understand whether, in my opinion, you know that in Hague appeal for peace, they don't have a police force. No police. I don't say we don't need lawyers. But basically there is a system which is we are going and passing through a very unique stage when you are talking about the peace and the global peace or the world peace, which we have been always trying to understand. This institution has been always on the front of understanding what is the very mechanism of the living cell. The body, the brain, the spirit, or the soul, and the mind. And we have come to a stage where engineering, medical, management, pharmacy, psychology, whatever subjects you speak about, we have to understand when there is a disturbance in this very mechanism. And we say, understanding the chemistry of mind is the main question. Understanding the nature of the soul itself. And equally so, I'll just make one or two sentences, the comments. The law of nature is common. It doesn't change with me or with you. So what should be the law for the global society to be peaceful? You know, friends, today the entire world is passing through a very most chaotic and a confused state, especially after the coronavirus appeared, whether it is natural one or the man-made one. Somebody will say it came from Wuhan, from that country, but possibly I had the fortune of discussing this on web. One of the great scientists from Britain who had gone to China and worked in that laboratory, he had said that time, this is only 20% strength of this coronavirus, 20%. If it comes out with 30-40%, what would have happened to the whole world? Is one situation. You know, all the prime ministers, the presidents, and the topmost people, including myself, as a teacher, we were hiding behind the doors. So what was that law which made us realize that there is an invisible force or energy which is called the spiritual component of life? जीवन की दिशा क्या है भाई? किसके लिए बात है ये पीस की? मुझे लोग पूछते हैं कि सर आप हमेशा वर्ल्ड पीस की बात करते हो, आपको शांति है? मेरा उत्तर होता है नहीं। तुम्हारे घर में पूरी शांति है? जज साहब बैठे हैं, सानप साहब है, देसाई सर है और हमारे घर के मेंबर सुधाकर जी आवाड़ बैठे हैं, जिन्होंने बहुत सुंदर बयान किया, लेकिन not as an expert in the field of law. But I remember Mr. Vijay Rao. He had said the rule of law of any nation must run to the close of life of the people, and the rule of the life of the people who make themselves must run close to the rule of Mother Nature, because the rule of Mother Nature is common for all. No variation, no change at all. This is the most scientific narration, scientific, logical, philosophical. You use any word, And this has been the situation. And you know, friends, I think a small brief film was shown to you, not with a pride or ego. We are not the makers. We are only instruments. घमंड हो गया तो बहुत तमाशा है भाई जीवन में भी. किसी देश का, किसी राष्ट्र का बात होता है तो trying to understand the very mechanism and your accountability and responsibility. This institution, along with law or all other branches, we have come to ultimately spending and spreading the message to the entire world, including all the lawyers and the judges and justices, and the men who try to develop the mechanisms. It's called as a 4-bar mechanism. As I said to you, the smallest of the smallest living cell, मराठी में बोलूंगा कि संत तुकाराम जी ने कहा है अनुरेणु थोकड़ा तुका आकाशा एवढा. Very simple word. ओम नमोजी आद्या वेद प्रतिपाद्या जय जय स्वसंवेद्य आत्मरूपा. The entire universe is conscious and reality, the ultimate truth. ये भाषा है 700 साल के पहले संत ज्ञानेश्वर की, 400 साल के पहले संत तुकाराम की और डॉक्टर अल्बर्ट आइंस्टाइन की. I have used the word Albert Einstein, Schrodinger, Penrose, all the greatest men of the whole world who have advised us as the chancellors, vice chancellors, professors, teachers, learned scholars like them, philosophers like them, to start the schools of consciousness and reality. नई दिशा है एजुकेशन की. वैल्यू बेस्ड एजुकेशन उसका नाम दिया गया है. And the most important part for any field, I'm telling, it should have a spiritual foundation. The very foundation of your life itself, how to live and how not to live. धर्म की व्याख्या दी है. What is law? What is religion? Religion is nothing but to find the ultimate truth, the ultimate reality. क्या है भाई, कैसे reality पता लगे? And the entire universe is described in a very scientific, logical, philosophical way, with appropriate laws of the nature, which is common. It's for the same, either for the Justice, Chief Justice, or the Prime Minister, or the President, and myself and yourself. It is common. And if this much understanding has been created by the law or judiciary, and the men like us, the engineers, the scientists, men of philosophy, men of legal profession, I think we can establish a little sense of peace and harmony. Tuning होता है. सोसाइटी को ट्यून करने का ये जो चेयर है, जस्टिस साहब बैठे हैं, बगल में 2 बड़े लॉयर हैं, टीचर्स हैं, एजुकेटर्स हैं. समन्वय करने के लिए क्या करना चाहिए, ऐसी बात है. ये भेद नहीं होना चाहिए. मैंने तो कहा कि गर्व तो नहीं, अब ये डोम बना भाई, मैं एक देहात से आता हूँ, छोटा देहात है, 1500 बस्ती का. गाय भैंस के तबेले में स्कूल, झाड़ू मारने का, गोबर निकालने का, फटे हुए गन्ने की बोरी डाल के उस पर बैठना. और शाम को जब गाय भैंसे चर के आती है खेती से, तो उनके गले की बेल वही बेल थी स्कूल की, बाकी तो मालूम नहीं था. कौन दिखाता है भाई ये दिशा? हु इज द क्रिएटर, द मेकर ऑफ दिस यूनिवर्स? ऐसी बातें, लंबी बातें लॉ में करना कि नहीं मुझे पता नहीं, बट यू आर द पीपल हु आर गोइंग टू बी द जजेस एंड क्रिएट एन ऑर्डर इन द सोसाइटी. इसके लिए लॉ एंड जुडिशरी का एक रोल होता है. आपको तो बाबा साहब अम्बेडकर की घटना तक अपन पहुंच गए, लेकिन देयर हैज टू बी अ सेंस ऑफ डिसिप्लिन एंड कैरेक्टर बिल्डिंग. उसके लिए लॉ जुडिशरी का रोल कैसे होना और कैसे नहीं होना. व्हेन आई से what to do and what not to do, how to live and how not to live. यहाँ दूसरी भी पार्टी बड़ी हो सकती थी, सेलिब्रेशन कैसे भी कर सकते भाई. ये सेलिब्रेट करके आपको सुनने से बेहतर इसके बाद में बड़ी पार्टी हो जाती है तो क्या फर्क पड़ता है. But this institution, possibly I am very proud, Rahul and the team of our vice chancellors and the scholars, we have been at least not on a wrong path. There is a divine message, divine light. ये जो बना है, जो फिल्म दिखाया आपको, उसमें जो कहा गया है, आध्यात्म शास्त्र की वैज्ञानिक प्रयोगशाला. क्या बोला है? स्पिरिचुअली ओरिएंटेड साइंटिफिक लेबोरेटरी है. ये लेबोरेटरी है भाई. आप किस में एक्सपर्ट हो, मैं किस में हूँ, क्या हूँ, लेकिन दिस इज द लेबोरेटरी एंड द एंटायर वर्ल्ड इज अप्रिशिएटिंग दिस वेरी मिशन. भारतीय संस्कृति, परंपरा, तत्वज्ञान की बात दुनिया में चल रही है. घमंड मत करो. सबसे बड़ी बात है नम्रता, लीनता, understanding the self and the society, the role of society and the role of your own self. I think that becomes the law and becomes the rule of law. And law and judiciary has a special role to play in the whole process of maintaining the order, creating not disorder but the order. Order in the life, in your own family. घमंड होता है भाई, बड़ी अमीरी है, 5 स्टार बेंगलो है, 5 स्टार रूम है, 5 स्टार कार है, सुख शांति नहीं. I had read an article, it's before almost 9-10 years back, in the Indian Express. ब्रिटेन की बात है. 9-10 साल का बच्चा बोलता है कि I feel like making a suicide. क्या भाषा है? 10-11 साल का बच्चा जो जीवन देखा नहीं, वो बच्चा लिखता है कि मुझे ऐसे लगता है कि मर जाऊं. क्या बात क्या है भाई ये? इतने छोटे बच्चे को ऐसा सोच कैसे आ सकता है? डिस्क्राइब किया है. इंग्लैंड की बात है, ध्यान में रखो. भारत तो उसके फॉलोअर बन गए. We are always following the West. But that child, उसका घर इतना सुंदर है, एसी है, सब 5 स्टार है, लेकिन माँ का और पिता का प्यार नहीं. आप समझ सकते हो. I don't want to criticize anybody, because ultimately, any global society, the law of nature is common. फर्क नहीं होता है. वो लॉ की याद रखो, उसको स्पिरिचुअल बोला जाता है. अध्यात्म शास्त्र का फाउंडेशन हो तो इट बिकम्स लिटिल बिट बेटर and maintains an order in the family, in the society, in the nation and the whole world. Vasudhaiva Kutumbakam ultimately leads to that stage, and possibly this becomes one system of the entire mechanism of maintaining the law and peace. Thank you, friends. I'm grateful to all the guests.
I request everyone to please stand for a standing ovation for Sir. And may I have a big round of applause for such inspiring words from Sir. I request all the dignitaries to please proceed downstairs for a group photo with these students. All these students, please remain standing as we are now going to have a group photo with the dignitaries. Thank you, everyone. I request all the students to please be seated as we are directly proceeding for the technical sessions for the day. To commemorate the 75th year of the adoption of the Indian Constitution on the eve of 26th November 2024, we have with us Honorable Advocate Dr. Sudhakar Abhar Sir, who will address the gathering on the journey of the making of the Indian Constitution for today's session. May I please welcome Sir. I request all the students to please settle down. Please sit as we are directly proceeding for these sessions. All these students, you are not allowed to step out. Shravan, please look into it that the students don't step out. Please settle down, everyone. All the students sitting on the top and all the students sitting downstairs. Please settle down. Disciplinary committee members, please look into it that the students are seated. Students standing on the top, please be seated. Kshitij, please sit. Faculty members and student members, please look into it that the students are well settled. Thank you. "26th November 2024 will mark the 75th year of completing the adoption of the Indian Constitution, the grand norm for our country, which lays down the foundation and the guiding principles for not only good governance, but as well as an accountable government. May I please welcome on stage Advocate Dr. Abhar Sir for his address on making of the Indian Constitution. Thank you. Please welcome Sir with a big round of applause, everyone. Thank you. There's this very short video for you. Can we please play the video? I'm so sorry. I request Sanya to please take the stage.
Good afternoon, respected dignitaries, distinguished guests, faculty members, and dear students. I am Sanya Shabin Nagaria from SYBBA LLB, and it is my honor to welcome you all to this enlightening session on the making of the Indian Constitution, a subject of immense importance and pride to every Indian. This year holds a special significance as we celebrate the 75th anniversary of the adoption of the Indian Constitution, a historic milestone that reminds us of the visions, struggles, and aspirations of our nation's founding leaders. Today, we delve deeper into this incredible journey, one that laid the foundation of modern India. To guide us through this fascinating session, we are honored to have with us a distinguished expert who has devoted his life to the understanding and upholding of the principles of our Indian Constitution. It gives me immense pleasure to introduce our guest of honor, Advocate Dr. Sudhakar Abhar Sir, a luminary in the field of law and an individual who has dedicated his life in the pursuit of justice and the understanding of constitutional principles. Over his career, spanning more than 5 decades, he has represented numerous landmark cases in the Supreme Court of India, various high courts and tribunals, leaving an indelible mark on our judicial landscape. Beyond the courtroom, he has contributed significantly to legal education. As an esteemed lecturer in legal history and jurisprudence, he has mentored countless students, inspiring them to pursue excellence and justice. Not only is he a brilliant legal professional, but he is also an accomplished author. His numerous books and writings reflect his profound understanding of law and history, including his efforts to document and analyze the making of Indian Constitution. In recognition of his lifelong dedication, he has been honored with prestigious awards such as the Jeevan Gaurav Puraskar, the Ahimsa Puraskar, celebrating his relentless pursuit of justice, truth, and peace. We are privileged to have him here today and share his insights on the making of Indian Constitution, a subject that lies at the heart of his expertise and passion. Before we proceed to hear from our esteemed guests, let us take a moment to reflect on his extraordinary journey through a short film, which highlights his contributions and life. I request the technical team to please play the video.
Advocate Dr. Sudhakar Rao Avhad is a distinguished legal professional known for his expertise in various areas of law, particularly in the fields of civil, criminal, and constitutional law. With a career spanning over 4 decades, Advocate Avhad has earned a reputation for his meticulous approach to legal matters and his unwavering commitment to justice. Advocate Avhad served as the chairperson of the Bar Council of Maharashtra and Goa from 2002 to 2003 and was a member from 1998 to 2003, playing a pivotal role in shaping legal education and practice in the region. He has worked as a legal advisor for the Pune Municipal Corporation and many other state and national level organizations. In recognition of his exceptional service, he was bestowed with the Lifetime Achievement Award by the Bar Council of Maharashtra and Goa, highlighting his significant contributions to the legal profession. He has been conferred with a PhD in law for thesis submitted to the Savitribai Phule University on the topic Global Dimensions of Human Rights and Evaluation of Fundamental Rights under the Indian Constitution. Apart from his legal practice, Advocate Avhad has contributed significantly to the legal community by engaging in research, writing, and teaching, thus shaping the next generation of legal professionals. Some of his notable books are about Real Estate Development and Regulation Act, Law Entrance Examination, and Judicial Services Examinations. His collection of poems named as Kavya Sudha has also been published and widely acclaimed. Advocate Dr. Sudhakar Rao Avhad has been awarded with various prestigious awards, Samaj Bhushan Award and Chhatrapati Shahu Ambedkar Phule
Invite and extend a warm welcome to Advocate Dr. Avhad sir. Please give him a huge round of applause.
Friends, clappings are made for 2 purposes. Sometimes you like it and you recognize it. And sometimes you are bored and tired and then you go on clapping and clapping. I hope these clappings are to welcome me here and thank you very much for the same. Friends, today I have been assigned the topic of making of the Constitution of India, the process whereby the Constitution of India has been made. Usually, the topic which is taught in the colleges, in the institutions and at seminars and symposiums are the contents of the Constitution. As our Honorable Chairman, he has said about the fundamental rights and directive principles. Today, I will not speak anything about the contents of the Constitution. I will not talk to you about what is included in the Constitution. I will just enlighten you. I will just have a dialogue with you how this constitutional document has been made. Friends, it is said about our Constitution that it is not a lawyer's document. It is a living document. Constitution of India is said to be a document of every generation. It is said about our Constitution that this Constitution has been made and such a methodology has been adopted for this purpose that this is everlasting Constitution of India. Everlasting means till the sun shines, till the moon shines, till then our constitution will be in force. Till then, Republic of India will be in force. Friends, nowadays, we hear of various narratives that so and so party will come into force, they will come into power, and they will destroy the constitution. They will change the constitution. We, the students of law, are not of any party, political party, or political viewpoints. Nevertheless, friends, let us know that whether any party in power can change the constitution, can break the constitution, or can amend the constitution to such an extent whereby it is made useless or not. And the framers of the constitution were well aware that in future, politicians and persons who will be control of the constitution will be of such a nature that they may not be fit, they may not be proper, and they may misuse the power to destroy the constitution itself. And therefore, in the course of the discussion hereafter, I will share with you how that galaxy of the constitution makers, that battery of the best people in the world, they have made this constitution wherein there is inbuilt mechanism has been made. If any wrong thing is done to the constitution, any making or breaking of the constitution is attempted, automatically system works and that will be restored back. History has witnessed 2 times that there had been severe attempt on the Constitution of India, whereby the Constitution was attempted to be overpowered by the politicians. The Constitution of India was attempted to be overpowered by the then persons in power. However, the forefathers of the Constitution, the framers of the Constitution, they have framed the Constitution in such a manner that nobody can, friends, break this Constitution or amend this Constitution to the extreme extents to undo the contents of the Constitution. How, that we'll discuss in a couple of minutes hereafter. For that purpose, we need to know how this Constitution has been framed, how this Constitution has been made. Usually, what you people discuss, what is in your syllabus are the laws. Who make the law? Who make the law? Parliament, or the state legislature, or the central legislature. Who has made the Constitution? Any legislature? Any state legislature? Any parliament? No, friends, there was no parliament. There was no state legislature. There was no central legislature. This Constitution has been made by the Constituent Assembly of India. This Constituent Assembly of India was that body of the lawmakers, constitution makers, which did consist of 389 members. These 389 members were elected as per the Cabinet Mission Plan of 1946. And when these 389 members were to be elected, and this Constituent Assembly was to be constituted before independence was granted to India. This Constituent Assembly was constituted before independence was being given to India. It was prior to Indian Independence Act of 1947. And then, as per the Cabinet Mission Plan of 1946, it was proposed that in India, now there shall be constitution made by the Indians themselves for themselves. They will make the constitution for themselves only. And therefore, in the preamble, if you read properly, it is said, we hereby adopt, enact, and give to ourselves this constitution. If somebody asks you, as a student of law, that who has made this constitution, then we, the people of India, we have made, adopted, and enacted, and given to ourselves this constitution. This is the beauty of the making of the constitution. Usually, laws are made by the parliament, but this constitution is not made by the parliament, this is made by the people themselves. People themselves are the law-making authority in respect of this Constitution of India. How, that we'll discuss. In discussing this paraphernalia of this making with the Constitution, when Cabinet Mission Plan provided that there shall be independence to be given to the Indian people. And secondly, there shall be Constitution of Independent India. Then it was proposed that the state shall state, princely states, the independent states, they shall send their 93 representatives. 4 commissionerates of the British people shall send their 4 representatives. And 292 representatives shall be elected from amongst the people. What was the criteria for election? Today it is adult franchise. Who has attained certain age, he can vote. But then, in the year 1946, July 1946, the voters were not adult franchise as today we have, but the voting rights were given to persons who were paying income tax, persons who were holding properties and paying taxes to the corporations. Such persons having proprietary rights alone, they were given right to vote. And accordingly, 292 people were elected, 93 were nominated by the states, and 4 were appointed or nominated by the English people. Accordingly, there were 389 people who tried to make this constitution. Immediately after making of the constitution, what happened, friends, that Barrister Jinnah, he said that we will not go with Indian National Congress. We will not be part of this Constituent Assembly. We want independent Pakistan. Accordingly, this Constituent Assembly got divided into 2, one for Pakistan, one for India. In Indian Constituent Assembly then, this part of the Constituent Assembly making constitution for India, there are only 299 people or 299 members. These people relentlessly worked for us for 2 years, 11 months and 18 days. They sat together for 114 days and they discussed the fundamental rights and other provisions. And thereby, they made this constitution. While making this constitution, it was not easy job. This is the largest democracy in the world. This constitution is taking care of about 150 crore Indians. This largest democracy is being regulated by this Indian constitution. This was not made, friends, in one day or one night. There were about 60 constitutions in the world were consulted. This Constituent Assembly consulted 60 constitutions. And when these 60 constitutions were consulted, what is good somewhere was taken. Say, for instance, this Constituent Assembly considered fundamental rights. Fundamental rights were taken from American Constitution. Say, for instance, process was taken from Japanese Constitution. Say, for instance, directive principles of state policy were taken from Irish Constitution. Say, for instance, internal emergency provisions were taken from Weimar or that is German Constitution. The constitution makers have not left anything in the world to study. And how they studied? For this purpose, we must make mention to 2 people first. This Constituent Assembly, in the entire original Constituent Assembly, friends, there were 250 lawyers. There were 75 barristers. And they sat together for more than 2 years or about 3 years, and they were discussing, and thereafter there was a distilled consequence in the form of the present constitution. It was like, to say in Sanskrit, it was Amrut Kumbha, whereby this constitution was made, which is everlasting and that is never to be destroyed. How? I will tell you. This work is remembered by 2 persons' personalities. First, Dr. B.R. Ambedkar, Bharat Ratna Dr. B.R. Ambedkar. And secondly, Sir B.N. Rao. We must not forget their contributions. How in one life people, they get and they attain such height in the life, I tell you. Who was Sir B.N. Rao? Do you know? Anybody? I will tell you 5 things about him. Sir B.N. Rao, he was ICS officer. Sir B.N. Rao, he was High Court judge. Sir B.N. Rao, he was a minister. Sir B.N. Rao, he was a person who has drafted constitution for Burma. And Sir B.N. Rao, he was the constitutional advisor to those 299 people. He was advisor to those barristers and the lawyers. And then after India became independent, he became judge in International Court of Justice at Hague. In one life, a person can live such a multiple life. Sir, friends, if one becomes a teacher, he says, I'm a teacher for life. One becomes a lawyer or advocate like me, he says, I'm an advocate for life. Somebody says, I'm businessman for life. This person, he lived so many multifaceted personality. Such people constituted the Constituent Assembly. What about Dr. B.R. Ambedkar, you must be knowing. Dr. B.R. Ambedkar, if you want to see his degrees, then one page will be less to mention his degrees. These people, these towering personalities that constituted the Constituent Assembly and that started functioning. When this Constituent Assembly started functioning, then on the very first day, this assembly was assembled on 9th December 1946 in Delhi. And when this assembly was assembled for the first time in 9th December 1946, and then proceedings started. This was the opening day. And then it is said how it was auspicious for Indian Constitution. There was a drizzling or there were showering in Delhi. It is said showering or rain is very auspicious for any good purpose. And this constitution making started with the gift of the God, that is rain, on that day in Delhi. That is how on 9th December this proceeding started. On 12th December 1946, Jawaharlal Nehru, the first Prime Minister and the esteemed member of this Constituent Assembly, he put forth the objective resolution. What today you read in the first page of the Constitution, that is, we the people of India, that is the objective resolution which was put forth for the consideration by late Jawaharlal Nehru on the second day of this assembly, that is the 12th December. That became ultimately the part of the Indian Constitution by virtue of the preamble to the Constitution. How to draft the Constitution was the question. We have taken in the Constitution, we the people of India, where from it has come. If you are studying this esteemed institution and you go out of the institute and somebody intends to test your intellect and ask you a question, gentlemen, are you from this esteemed constitution establishment and institution? Please tell me where from the word comes we the people of India. Anybody? Anybody else? That is what we want to know today. I am not going to teach you all the articles, all the provisions. It is about the Constitution, not in the Constitution. And friends, the words, we the people, it comes from the poem written by James Wilson, the American poet. So, James Wilson, he has written the poem, and from that, the words were taken, Abraham Lincoln, and then Jawaharlal Nehru, and then objective resolution was framed. That is how the word, we the people of India, it came. And in the preamble, just now our chairman has said, there are the words, liberty, equality, and other elements. Where from it came? It has been taken from French Constitution. So, it is said sometimes that Indian Constitution is a borrowed constitution. Nevertheless, we studied all the entire word phenomena. We studied entire word books regarding constitution, constitutional authorities, and then taken something good from each. And then we have made this constitution. While making this constitution, this Sir B.N. Rao, he traveled throughout the world. He met most of the dignitaries in the world. He met also the chief justices of different Supreme Courts of the different countries, and then what is good there, he took, and then that has been included in Indian Constitution. Or that there had been discussions and deliberations, and the people, they have devoted their time for years together. For 3 years, this was being discussed. When this was being discussed and provisions were being discussed, there was a provision which was not included, but should have been included. Today you will find that once the Supreme Court judge or the High Court judge retires from the post, immediately next day he's appointed to some post. He becomes a governor, or he's appointed as the chairman of some other committee, or he appointed as the Human Rights Commission. It was discussed in the Constituent Assembly that such people should not be appointed. There shall be independent judiciary, and so as to maintain independence of the judiciary, such judges of the Supreme Court and of the High Court, they should not be appointed to any other post. This was in the draft made by the then chairman of the drafting committee, Dr. Ambedkar. However, when the final draft was made and approved, this line was eliminated, taken away, and this restriction so as to how the appointments of the retired judges of the High Court and Supreme Court to various constitutional posts, it has been deleted, and the reasons we are discussing today. We see everywhere that as soon as judge is retired, next day he is appointed to some post. There has been a survey of the present Supreme Court, and a critic has made a survey of the Supreme Court decisions, judges and their decisions. And he found that the critic has found that whenever any person is elevated to the Supreme Court, first 1/3 days, he is anti-government. He gives decision against government. For the middle of 1/3, he is pro and anti-government mixed. And then remaining 1/3, at the time of retirement and few years before that, he becomes pro-government. The critic therefore says, where is the independence then? And therefore, while drafting the Indian Constitution, it was attempted to see that there is a balance cut between the judiciary and the executive. However, you'll find there is no perfect balance nowadays. We'll discuss hereafter. However, this process started, discussion started, and then there is a crystallization of various provisions. By virtue of various provisions, the Constitution has been drafted. Provisions were drafted, they were enumerated, and a book was made. But it was felt then that let us not print it, let us write it. So, today, what you people, you study in your library and what you have in hand is a printed book on the Constitution. This is not the original Constitution. Original Constitution, friends, is in handicraft, and that is handwritten Constitution. There are 2 copies of the handwritten Indian Constitution. One is in Hindi and one is in English. That English version, which was so drafted by the drafting committee, and that was to be reduced into writing, Jawaharlal Nehru then, being the Prime Minister and the member of the Constituent Assembly, proposed that it shall be handwritten in calligraphy, in italics. And they started searching who can be the best person to write it. And then, when they started searching it, who can be the best person to write in italics and handicraft, then they found that in Delhi, there was one family, Prem Bihari Narayan Raijada. There was a family of Prem Bihari Narayan Raijada in Delhi, and they were best at that time in India as to calligraphy. Nehru called him, and there was a personal meeting. A person, writer, simple writer. Then the person of stature of Jawaharlal Nehru met him and asked and requested him, please write this Constitution in your own handwriting. He said, sir, I will write, but I have 3 conditions. Friend, Jawaharlal Nehru, international figure, first Prime Minister, and this gentleman putting conditions to him that I have got 3 conditions. And then Jawaharlal Nehru asked him, that gentleman, all right, will abide by your 3 conditions. What are your wishes? He said, sir, first, I will not take any remuneration. Even though we are poor from this country, nevertheless, we honor this event, and therefore, we will not accept any consideration for that. I will not accept any honorarium for that. His was first condition. You'll ask him, what is there then? He has not accepted. But on the comparison of this, there was American Constitution. And when American Constitution was being written and was being drafted, the person who wrote it, he has charged very huge amount for that. So rich people have charged very huge amounts, but poor people in drafting Indian Constitution, they have not asked for even a penny for that. Is the beauty of the writing of the Indian Constitution, we shall remember. And that gentleman was Prem Bihari Narayan Raijada from Delhi. Then Nehru asked him, that gentleman, what is your second condition? He said, sir, I will write it free of cost. I will do it as per your desire. But on every page of the Constitution, I will write my signature. I will put my signature. You'll find today also, in the original Constitution of India, on every page, there is a signature of Prem. He has put his short form, Prem Bihari Narayan Raijada. He has signed as Prem. No other person has signed the Constitution on the middle pages. He is the only person to sign from first to last page of the original Constitution. So, simple clerk or a common man, his signature is on the Constitution, and that will remain in force till the sun shines and the moon shines. That was Prem Bihari Narayan Raijada. Nehru said, okay, we'll abide by that. You put your signature. What is your third condition? He said, sir, on the last page of the Constitution, I will put my grandfather's name. A question was put to him, why your grandfather's name? His grandfather's name was Saxena. His mother's father was Saxena. He said, his name I will write. A question was put by Jawaharlal Nehru to him, gentlemen, why you want to put his name? He said, look, sir, when I was a small boy, I lost my parents. I was an orphan. And I was taken care by my mother's father, my grandfather. And therefore, I must honor him forever, for eternity. And then, on the last page, name of Mr. Saxena appears today also. That is how, with the Constitution, these two people, they have attained eternity. This Constitution was being written. This Constitution was reduced into writing by Prem Bihari. He then sat at a room in Parliament to remember him, to remember that event and that historic event. That room today is called as the Constitution Club of India. That room where he sat for so many days and he reduced into writing, that room is now called as the Constitution Club of India. Thereafter, Constitution was written, and then when Constitution was written, then it was thought fit that this is handwritten Constitution. There must be some handicrafting done. This work was given to Nandalal Bose from Tagore Ashram. Tagore, Nandalal Bose, he has done all that handicrafting. If you go to the first page of the Constitution of India, that is preamble, then you will find there is handicraft constitutional first page. That has been done by Nandalal Bose from Tagore Ashram. Then, in addition to all this, this has been done. And then when issue came as to signing on the Constitution, then all the members of the Constituent Assembly on 24th January, they signed on the last page. First to sign was Dr. Rajendra Prasad, who was the then permanent chairman of the Constituent Assembly, and last to sign was Firoz Gandhi, husband of Indira Gandhi. There were 284 signatures on the last page of the Constitution. That is how that constitutional document has been made. The ink used for the writing of the Constitution, friends, that was the special ink, because this was not Parliament's law. This was not ordinary central legislature law. This was the law which is to be which was there to govern India forever. Yavat Chandrao Diva Karoti. In Sanskrit, it is called as Yavat Chandrao Diva Karoti. Till sun shines, till moon shines, this document will be preserved. This document shall rule the country. And therefore, the ink was of a special ink was made in India. That ink, life of the ink is 1,000 years. The ink with which our Constitution has been written has its 1,000 years life. And today, you know, this Constitution of India, which is not a normal document, it is a holy book of India. I am a Hindu, Bhagavad Gita. Somebody is Christian, Bible. Somebody is Muslim, Quran, and so many our holy books. It is individual holy book. However, this is a secular holy book of India, and therefore this book, this is a constitutional document, is not ordinary document or a printed document. This document, the Indian Constitution, when that is to be found, This is put, the original handwritten constitution is put in the parliament today. And that is put in a specially made helium box. And therein, that original copy is put. There is a special machinery appointed by the Parliament of India which looks after this monumental historic document every 6 months. There is a machinery, there are scientists who are appointed, they go there and every 6 months they inspect the original copy and see that whether that is in good condition or whether it requires any further treatment. That is how the revered document, that is how the respected document is preserved for eternity in the Parliament House. It was thought fit then, when the language of India was to be, or the language for the nation was to be selected, it was thought fit that Sanskrit should be the language. In fact, Dr. Ambedkar, he was for Sanskrit as the national language. But at the end of the discussion, in the Constituent Assembly, from Sanskrit, the majority shifted to Hindi, and then Hindi was made the national language. However, then it was thought that we have written English, but what about the national language is the Hindi language, and therefore its Hindi version was to be made. Its Hindi translation was to be made, and that also was in handwriting. Krishna Vaidya, Vasanta Krishna Vaidya from Maharashtra, he translated it into Hindi, and its Hindi version was made at his behest. There are now 2 volumes. One is Hindi, other is in English. And both of these two are put in the Parliament House and being inspected after every 6 months for its protection. Why? Why this document is so revered? If our books, my books, your college library books are in the library and in the cupboards, why this document is taken care of? What is the reason? Because friends, this is the reason why I am here. This is the reason why you are here, and this is the reason why she is here. Because of this constitution, we get our status, we get our rights, and because of which we are the citizens of India. Entire Indian citizenry, our rights are given, protected by the Constitution of India. This is the beauty of the Constitution, and hence, this document is said to be document of every generation. You'll ask me a question. Sir, you are always saying, you have said 10 times that this document will be enforceable for so many years and eternity till sun and sun moon is there. Why so far? Then it is rigid. It is fixed. It is once made and will be the same for thousands and thousands of years. No. It has been said by the Supreme Court of India in one of the judgments that this is the document of every generation. Means this is flexible constitution. This document is such made, this constitution is made in such a fashion that this is a flexible constitution, means constitution will satisfy needs of every generation. And if necessary, there can be necessary modifications so as to suit the purpose of the society. If at all, Indian citizenry needs some change in the constitution, then there is a provision made in Indian constitution so as to make amendment in the constitution. So, accordingly, this is a living document. This is a dynamic document. As the needs will change, then document can be changed. This is the beauty of Indian constitutional law. You'll ask me a question then, that if this is the constitution made, it is a constitution of every generation, will take the need of the generations. Then, question arises, that who will take care of this constitution? Who is the guardian of the constitution? Who will protect this constitution? And protecting of the constitution, control of the constitution was a controversy immediately thereafter. Who shall control the constitution was the controversy immediately after first election of the Parliament of India. And when first Parliament assembled, then only this process started. There was a twofold dialogue. One was led by Jawaharlal Nehru, other was led by Dr. Ambedkar. Dr. Ambedkar, he was advocating rights of Hindu female. Dr. Ambedkar, he said, and he was of the firm view that independence has been given, Equality has been promoted. Nevertheless, amongst Hindus, there is no equality. Hindu female had no right in property, and he therefore put forth Hindu Code Bill. He advocated Hindu Code Bill. He was working on Hindu Code Bill, and then he was the law minister. He was the cabinet law minister in parliament. But Jawaharlal Nehru was against it. The first prime minister was against it. He was afraid of the Hindu votes. If at all such a law is made, then Hindus will be voting against. And therefore, he advised Ambedkar not to go through this Hindu Code Bill, because there were frictions in two great personalities. On one side, the constitution maker, Dr. Ambedkar. On the other side, Jawaharlal Nehru, the first prime minister in parliament. This friction resulted into resignation of Dr. Ambedkar. Friends, today, for becoming a corporator, for becoming an MLA or say member of parliament, what a trouble people are taking. But then Dr. Ambedkar, who had been a cabinet minister in Parliament of India, first law minister, because of the rights of the Hindu female, he threw away his resignation, he resigned from the ministry, and then he said that if rights of the Hindu female are not being protected, I will not be part of this parliament. He resigned his membership as well as his ministership. That is how there was inbuilt mechanism provided, how the people, they are guided by the torch of the wisdom shown in the Constitution of India. When this constitution was made, this constitution was adopted on 26 November 1949, Dr. Ambedkar said, had Ambedkar not been there, friends, we had not been here. There had been a dictatorial state in India, I tell you. Because of Ambedkar, we are here. And where Ambedkar was speaking in the house, he said, I want to burn this constitution. Who said? Dr. Ambedkar, who worked for 3 years for making up the constitution. He said that I wish to burn this constitution. Next day in the Rajya Sabha, a member of parliament asked him, Doctor, you have worked on this constitution. You have put your tireless efforts in this constitution for 3 years and then made this constitution. And after that you say you want to burn this constitution? Why? It was shocking to everybody. It shook everybody in the parliament that great Dr. Ambedkar, he was saying, I want to burn this constitution. He worked and he wanted to burn this and destroy it. When question was asked to him, he gave a very interesting answer that applies, friends, today also. What answer was given, I'll tell you. He said, look, we wanted to construct a temple of democracy. We wanted to construct a temple of democracy and to install idol of God therein, statue of God therein. Alas, before we install God, Rakshasa has come and started residing therein. This was his reply in Rajya Sabha, in first Rajya Sabha. What is the consequence? What he said? To understand, he said that we wanted to have the democracy in a good manner, but in the first election, who were elected and who dominated the leadership in the house, he said that democracy has gone to bad hands. When? Not today. When? Not this decade, not last decade, in the first year itself, when the constitution came into force and the first parliament was elected in the year 1951-52, then only this process of going, this democratic aspect in the bad hands started therefrom. And therefore he said, I want to burn this constitution. Thereafter, about this constitution, in this Constituent Assembly, there were 15 female members. You'll ask me, what is the new? There may be 10, 15, or there can be one also. But in the progressive democratic nation like United States of America, there was not even a single female member in the drafting committee and Constituent Assembly. In our Constituent Assembly, there were 15 members, including from Dalit as well as from Muslim. One Dakshayani Velayudhan from South She was the Dalit member of the Constituent Assembly. One, Kadisha Begum Rasul was the Muslim member in this assembly. Thus, Velayudhan has written a very nice quote, I tell you. She says about Dr. Ambedkar. Velayudhan says about Ambedkar, she says that, as you say, in the pages of Bhagavad Gita, everywhere Lord Sri Krishna has parked himself. In the pages we see Lord Sri Krishna. Because in every page of the Bhagavad Gita, we have something about Sri Krishna, Lord Sri Krishna. She says, like this, when you take away the pages and articles and the provisions of the Constitution of India, Dr. Babasaheb Ambedkar has parked himself in the Constitution. Therefore, see the beauty, how one can say in 1 hour, one can say in 10 pages, Velayudhan madam says in one sentence. She says, like Sri Krishna has been parked in the pages of the Bhagavad Gita, time is over. Like as the Lord Sri Krishna has been parked in that Bhagavad Gita, likewise, Dr. Ambedkar, he has been parked and he is visible through the pages and articles of the Constitution of India. This is the beauty of Dr. Ambedkar. Dr. Ambedkar's version, how these people were great, how that was a galaxy of the people in the Constituent Assembly, they have made, friends, inbuilt mechanism. They were knowing that in future, political people will come in power who will not be so good, who may not be having that sense of justice. And to control them, there has been the auto-control system provided. Such mechanism has been provided, I'll tell you, with the help of the case of the Supreme Court. The battle for control of the Constitution, who shall control the Constitution, whether judiciary shall control or executive shall control, it started in the year 1950 itself. You will be surprised that the same Constituent Assembly, the same constitution makers who made this constitution and gave this constitution to ourselves on 26 November 1949, immediately within few months' time, they started taking away fundamental rights. Who have taken fundamental rights away from us? The process started not from the parliament, but it started with the same Constituent Assembly, the same lawgivers, the same constitution makers. They have started taking away the fundamental rights. Because, friends, this Constituent Assembly, who has made this the Constitution of India, it worked for 3 years as the Constituent Assembly, and thereafter for about 1.5 years as the Parliament of India, as interim parliament. When this Constituent Assembly, constitution-making function was over and started functioning as interim Parliament of India, started taking away fundamental rights. And then, at this stage, we came across, the constitutional experts came across that who shall be having control, whether this constitution shall be controlled, because this is a document, maybe Holy Book of India, but there shall be somebody to execute it. Who shall execute it? And to execute it, there were two claimants. One was executive, the president, the prime minister, the council of ministers, and on the other side there was a judiciary. Who shall control it? If it is given in the hands of the politicians, then they will exploit it to their benefit. And therefore, it was thought fit that it shall be controlled by the judiciary. And therefore, there has been a judicial control over the functioning of the Constitution of India. This came, wherefrom it came. And for this purpose, the Indian judiciary followed the decision of the United Supreme Court, which has been delivered in the year 1803 in the famous case of Marbury versus Madison. In case of Marbury versus Madison, which has been decided in the year 1803, Chief Justice Marshall of the American Supreme Court, he has said, any action of the executive, any action of the parliament their Senate there, it can be, or Congress there, can be considered and reviewed by the judiciary. That can be set aside if it is contrary to fundamental rights of the American citizens. Same formula we have followed, the Indian Supreme Court has followed in India, and there has been doctrine of judicial review made applicable. Accordingly, this judicial review doctrine has been accepted to control the Indian constitutional function by the Supreme Court. To conclude, I will take you to the next aspect. How sometimes rights of the citizens are at the behest of the executives, and how sometimes the courts also fail to satisfy the people's demand. Not only Parliament has failed, not only executive they have failed, but India, even Supreme Court has failed on many occasions. I'll tell you one instance thereof. It is very difficult, friends, to speak about the Supreme Court, to speak about the judges, to speak against the judges of the Supreme Court. I know, for 47 years I am doing it, I know the limit to criticize or to say something about it. With that respect to the judiciary, with that respect to the judges, I am quoting this case for your consideration. See how sometimes Supreme Court failed in India to discharge its duties properly. That was the case of ADM Jabalpur versus Shivkanta Shukla. Those people who have studied the Constitution must be knowing ADM Jabalpur versus Shivkanta Shukla. It goes to 1975-76. It was a case wherein, friends, when there was Mrs. Gandhi was in power, the Congress had majority with them. When she was in power, she has enacted a law called as MISA, Maintenance of Internal Security Act. And as soon as this act was enacted, her election to the parliament was declared by the Supreme Court as void. As soon as she was defeated in the election, she declared thereafter emergency. She claimed the emergency. And all the political parties, opposite political parties, were put in jail under MISA Act. And they were in jail for more than 18 months without any inquiry in this India. Today somebody goes to the jail for one day, immediately we go to the High Court and Supreme Court and we go away with the Article 32 and we provide for various writ petitions, including habeas corpus petitions. But thousands and thousands of people, including today's Prime Minister and today's ministers and so many people were put in jail for more than 18 months. Petitions were taken to 9 high courts. And 9 high courts said that these provisions in MISA Act is unconstitutional, is ultra vires, and these people shall be released forthwith. 9 high courts have said. Against this, additional district magistrate, Jabalpur, he had been to the Supreme Court in appeal. ADM Jabalpur versus Shivkanta Shukla. When against 9 high courts, appeal was filed to the Supreme Court of India, issue had been referred to the 5 judges bench. Justice A.N. Ray was the Chief Justice of the Supreme Court. There were 4 other judges. One was Justice Y.V. Chandrachud sir. Another judge was Justice P.N. Bhagwati sir. Another judge was M.H. Bek sir. And the 5th judge was Justice Hansraj Khanna. When this case was referred, everybody in India, almost all lawyers in India, all legal luminaries in India were of the firm opinion that yes, Supreme Court will say and will invalidate that law because it is contrary to fundamental rights of the citizens. But to the surprise of the galaxy of the lawyers in India, to the surprise of the battery of the excellent flavor of the law teachers also, they were shocked. And the Supreme Court, by 4 versus 1 majority, held something otherwise. One day before that judgment came, Justice H.R. Khanna, who was the dissenting judge in this case, he was just roaming in his house. His daughter, she woke up at late hours and she said, "Father, why you are worried?" And when a question was asked to him by the daughter, that "Father, at late hours, why you are roaming in the house?" He said to the daughter, and that is how there is inbuilt mechanism in Indian Constitution. As friends, if you have got a wound, the God has provided for, nature has provided for inbuilt mechanism, and automatically it comes and it is healed. Likewise, constitutional damages, constitutional injuries are automatically healed. And this healing process is this interesting case. When there was 4 and 1 judge against, that judge said to the daughter, look daughter, tomorrow I have got a choice to make. Either I'll be the Chief Justice of the Supreme Court, or I'll be at home. I'll go home. I'll be fired out. I have to compromise with my principles. If I compromise with my principles, I'll become Chief Justice of the Supreme Court. And if I don't, then I will not become Chief Justice of the Supreme Court. Next day, he went to the Supreme Court. A judgment was written in the Supreme Court. It was 4 versus 1 judge written. Justice N. Ray, Justice Bhagwati, Justice Beg, Justice Y.V. Chandrachud, they delivered the majority judgment. And this Hamsraj Khanna, he wrote the dissenting judgment, the minority judgment. By 4 versus 1, this very Supreme Court, of which we talk so high about today, said that in case of proclamation of emergency, there can be no fundamental rights. There is nothing strange in saying so. But a question was put by the judge to the Attorney General of India, who was arguing before the Supreme Court. Attorney General of India was arguing before the Supreme Court, and judge put a question to him, that gentleman, do you mean that even right to life is not available to Indian citizen? And without any respect to the citizenry and fundamental rights, the Attorney General, you must be knowing the first law officer of India. Attorney General said to the judge, no, sir, Lordship, even right to life is not available during proclamation of emergency. This is in this India. This has happened in the portals of the Supreme Court. And by 4 versus 1 majority, the Supreme Court has held, yes, during proclamation of emergency, fundamental rights are suspended, including Article 21 of the Constitution. Even right to life can be suspended, was the question answered by the 4 judges of the Supreme Court. One judge only said, no, right to life, that is Article 21, can never be suspended, including proclamation of emergency. In India then, there was blackout, news blackout. When there was news blackout, not even a single sentence was printed in Indian media, print media. There was no version, there was no discussion in India. But in New York Times, there was half-page news. In India, nobody took care of it. But in New York Times, there was half-page news. And it was said by New York Times in praise of Justice Hamsraj Khanna that it has been said by the reporter, if at all in India the temple of democracy is reconstructed, then the statue of Hamsraj Khanna is to be installed in that temple of democracy. That has been said about it. Therefore, friends, in India, there were such judges of integrity, and because of which he just spared and he gave up his claim to become the Chief Justice of the Supreme Court. And thereafter, Justice Ray, he retired, and then those 3 judges, Justice Y.V. Chandrachud, then Justice P.N. Bhagwati, and Justice M.H. Beg, they became the Chief Justices of the Supreme Court. But this person, he sacrificed this highest post in life for your and my rights. And hence I have said that this constitution and the rights under this constitution, tenure of this constitution is yavat chandro diva karoti, till sun shines and till moon shines, this constitution will survive because we have produced such people, we have produced such judges, and because of that, there is eternity in this constitution. Friends, when this judgment was pronounced, thereafter, in my 47 years of teaching and 47 years of practice, I never heard a word about Supreme Court judgment which has been heard about this judgment. When there was, in Delhi, a seminar was being held like this, that was in the memory of late Nani Palkiwala Memorial Lecture Series. And that was being attended by Galaxy of the Speakers. The judges of the Supreme Court attended, including the Chief Justice of the Supreme Court. And in that seminar, Chief Justice of the Supreme Court has said something about this judgment of the Supreme Court. The subsequent Chief Justice said that this judgment is not good law and that requires to be put in dustbin. Who has said? The Chief Justice of the Supreme Court. About what? The judgment of another Supreme Court Chief Justice. He said that such kind of judgment is not respected thereafter. That judgment, friends, has been thereafter overruled, and that has been very recently overruled in Puttu Swami, Justice Puttu Swami case. Very recently, by 9 judges' judgment has been overruled by 9 judges' judgment. It is very historic. Judgment of father has been overruled by son, being the Chief Justice of the Supreme Court. Friends, this is a short story. I know that there is a limitation for my time. This is our whole day program. But by the way, I will tell you few things before I part with. Firstly, anybody of you have gone to the Supreme Court? If you go to the Supreme Court and you go to the Chief Justice's court, just now we have seen the dome of the Supreme Court. There is Chief Justice. There Chief Justice sits. And in Chief Justice's court, behind the Chief Justice, there is a word put, yato dharmastato jayaha. Behind Chief Justice, there is a sentence, yato dharmastato jayaha. Anybody know where from it came? कहाँ से आया? यतो धर्मस्ततो देयः. Friends, there is a very interesting story whereby the word came yato dharmastato jayaha, that is put behind the Supreme Court Chief Justice of India when there was Mahabharata and that war was declared. That 18 days war was there. On one side there was Lord Sri Krishna and all other things we know from our history. One day before, all were going to elders for their blessings. Kaurava and their chief, they had been to their mother and they touched the feet and they asked for the blessings. What mother would have said? Vijay Bhava. Any mother who would have said, tomorrow he is going to battle and there are 100 sons of Gandhari, they are going to battle. She would have said, Vijay Bhava. But she had not said. She said, Yato dharmas tato jayaha. Means, where is the truth, there shall be the victory. So it is not the lust for the son or for the near and dear one. They shall be delivering justice. Where is the truth? There is the victory. There shall be judgment and there shall be no fear and favor to be shown. There is another thing before I part with, I'll tell you. You go in India anywhere, on the front of the court it is said, Nyaya Mandir. Do you know where from it came? Anybody? महाराष्ट्र में, भारत भर में, जहाँ जहाँ न्यायालय होते हैं, उनके बाहर लिखा होता है न्याय मंदिर, Temple of Justice. Where from it came? I tell you a short story. It is regarding Supreme Court. I will tell and then I will finish. I know that you are tired. Previously, when India became independent, there was a federal court. There was no Supreme Court. As per the Government of India Act of 1935, there was a federal court. Justice federal court. And then on 26 January 1950, the Supreme Court of India was established. It started functioning on 28th January 1950. First Chief Justice was naturally Harilal Kaniya, H.M. Kaniya. And then Supreme Court started functioning in the year 1950. Till then, Supreme Court had no its separate building. That separate building, today we witness, it had no separate building. Supreme Court was functioning in some part of the parliament itself. Some part of the parliament was allocated to the Supreme Court and their Supreme Court was functioning in the parliament itself. You will be surprised. In the beginning, Supreme Court had only 1+7 and it could sit only 10 to 2 and 10 to 12 and 2 to 4. And it did work for few years, only for 21, 22 days in a year. This Supreme Court started functioning, but it was then thought fit that there shall be a very nice building of the Supreme Court. And in the year 1954, 17 acres of land was allotted by the government of India to the Supreme Court building. And then the construction started in the year 1954. We are proud. Maharashtrian engineer Deola Likar was the chief of that construction. And under his supervision, construction was completed. And in the year 1958, the ultimate housing was to be done, functioning was to be done. A function was held under the chairmanship of the first president, Dr. Rajendra Prasad. Jawaharlal Nehru was there, Dr. Rajendra Prasad was there, and the galaxy of the judges and all other dignitaries were present. And then, in that speech, Dr. Rajendra Prasad has said that now we have constructed this temple of justice, and now justice will be given to the people of India. Friends, till then, since then, now everywhere when any court is constructed, court building is constructed, it is said to be temple of justice or Nyaya Mandir. Friends, these are very few things. In fact, I had many things planned for you, but time is restrained. I wanted to consult you why we wear a black coat, why we wear bands also. There are many things to be shared, but in due course of time, I will come back and I will share the things. By this time, I will conclude for the time restraint and constraint. Friends, thank you very much for cooperating with me. I'm really thankful to the institution for giving me this opportunity and calling me here and giving me this time space for dialogue with you. Thank you very much.
Thank you so much, sir, for such an inspiring session. Your words have left a profound impact on all of us. As we come to the end of this session, on behalf of MIT World Peace University, it is my privilege to deliver the vote of thanks. First and foremost, I extend my heartfelt gratitude to Advocate Dr. Sudhakar E. Avhar sir for taking time out of his busy schedule to join us today and share his profound insights. Your dedication to the field of constitutional law and your willingness to enlighten us with your vast knowledge is truly inspiring. We deeply appreciate your efforts in making this session enriching and memorable for all of us. I would also like to sincerely thank our respected dignitaries, faculty members, and students. Thank you. Students, please note, we will take a short break. We expect everyone to return promptly at 2:30. Following the break, we will take 2 sessions whose guests have already arrived. So please ensure to return on time. Thank you.
will be starting shortly. I will request you all to please remain silent.
I request you all to please kindly settle. Good afternoon, respected dignitaries on the dais, distinguished guests, faculty members, and dear students. I am Satyam Singh from second year BLLB,
And I, Akansha Verma from third year LLB.
and it is our honor to be the anchors of the first session of 4th International Symposium on Law and Peace. As we begin this important event, let us take a moment to reflect on the inspiring journey of Dr. Vishwanath Karad, MIT World Peace University. Built on the values of education, research, and peace, MIT World Peace University has over the past 4 decades grown into India's one of the leading institutes. With an alumni spread across the globe, it is known for its commitment to excellence and holistic growth. Today, as we come together for this symposium, we aim to create a space for meaningful discussions, exchange of ideas, and lasting inspiration.
Our theme for the first session of the 4th International Symposium on Law and Peace is Changing Dimension of Legal Education. Legal education today stands at the crossroads where traditional methods meets the demand of rapidly evolving world. The scope of legal education now extends far beyond courtroom, encompassing technology, policy, and global issues. This session aims to explore these new dimensions, shedding light on how legal education can shape well-rounded professionals ready to address the challenges of future. To guide us through this crucial discussion, we are privileged to have a panel of highly respected and accomplished experts with us today.
I now request Professor Parimal Sudhakar sir, School of Government, Professor Anjali Sane ma'am, Dean of School of Economics and Commerce, to felicitate our guests. Please join me in welcoming our distinguished panel. Anjali ma'am, I'd like you to felicitate Dr. Sudhakar Malegaonkar sir, Specialist in Labor Laws and Industrial Relations. Advocate Ranit Basu, partner in Bridget Law Partners. Please put your hands together for our guests.
Before we proceed further, I request our media team to capture this memorable gathering with a group photograph. Of all the dignitaries on the dais, I request the panelists to kindly come forward for the photograph. Yes, ma'am. Thank you. Thank you all for joining us this afternoon. To formally welcome you, I invite Dr. Anjali Sani Ma'am, Dean of School of Economics and Commerce, to deliver the welcome address.
Thank you. On behalf of Honorable Founder President, revered Professor Dr. Vishwanath Karad sir, Honorable Executive President Shri Rahul V. Karad sir, Honorable Vice Chancellor Dr. Ravi Kumar Chitnis sir, Associate Dean Dr. Purnima Inamdar, and on behalf of the entire team at the 4th International Symposium on Law and Peace, it is my proud privilege to welcome all the dignitaries on and off the dais for session 1 on the topic Changing Dimensions of Legal Education. It is our privilege to have with us today Advocate Dr. Shrikant Malegaonkar, who is an advocate with Malegaonkar and Associates, and Advocate Ranit Basu, a partner in Bridgehead Law Partners. Thank you both for sparing time from your extremely busy schedule and joining us today to enlighten young minds. कुछ पंक्तियां सर आपके लिए, बच्चों आप भी सुन लीजिए. काम करो ऐसा कि पहचान बन जाए. काम करो ऐसा कि एक पहचान बन जाए. हर कदम ऐसा चलो कि निशान बन जाए. यहाँ जिंदगी हर कोई काट लेता है. जिंदगी जियो इस कदर के मिसाल बन जाए. Few examples, few idols are sitting in front of you, dear students, who are a role model in the field of law, in the field of justice for all of us, and I'm sure that their thoughts are going to enlighten us today on the theme which focuses on changing dimensions of legal education. The session bears specific significance in contemporary times because it highlights the need to adapt legal education to the changing needs of the profession and society. Legal professionals are needed to meet the challenges of a growing economy and advance social justice. The legal market has changed due to globalization and liberalization, and new technologies have created a need for new subjects. Private universities like MIT World Peace University are playing a significant role in improving the quality of legal education. The syllabus needs to be updated regularly to prepare lawyers and judges for the challenges of the contemporary world. The number and significance of law roles is increasing as the legal system expands and becomes more complex. Modern legal education should integrate technology into the curriculum, such as using legal databases for research and providing e-libraries. Moreover, in the face of artificial intelligence playing a role now, the day is not far away when the justice will be delivered not by people in person, but by artificial intelligence, basis the case studies so far. The session today will throw light on how legal education serves a number of objectives and has a number of aims to be achieved in lieu of the changing society. In the words of Dr. Nelson Mandela, education is the passport for the future, for tomorrow belongs to those who prepare for it today. It is our privilege to welcome the dignitaries who will help us in preparing the students for the future that awaits them. Once again, on behalf of the entire team at ISLP, it is my proud privilege to welcome the guests for today and also the dear students who are present in large numbers, especially in the post-lunch session. I hope that this session will be an enriching one for all the faculty and students at the MIT WPU School of Law. Looking forward to an enriching session. Once again, welcome, welcome one and all.
Thank you, ma'am. Ladies and gentlemen, as we delve into the core theme of today's symposium, we have prepared a special session video that highlights the rationale behind the essence of our discussion and the vision of this event. I now kindly request our technical team to play the session video.
Welcome to the session on changing dimensions of legal education. In today's fast-paced world, the role of legal education is more critical than ever. As globalization and liberalization reshape our legal landscape, the need for adaptable legal professionals grows. This session will explore how legal education must evolve to meet the demands of a dynamic economy and promote social justice. Private universities have become key players in enhancing legal education. By integrating new subjects into their curricula, they prepare future lawyers and judges to tackle complex legal challenges. Modern legal education must embrace technology. Utilizing legal databases and e-libraries equip students with essential tools for contemporary practice. This session will highlight how legal education serves multiple objectives in a changing society. It is vital for law professionals, students, and faculty across universities to unite in shaping our future and that of the next generation. We will address pressing issues such as funding and resources, exploring necessary reforms that can enhance our educational frameworks. Join us as we engage in this important conversation about transforming legal education for a brighter future. Together, we can ensure that our systems reflect and anticipate evolving needs of society.
Thank you, team. Thank you, team. Next, I would like to invite the moderator for this session, Dr. Vikrant Yadav, Associate Professor at MIT World Peace University, to address the gathering and share his insights with us. Dr. Yadav holds a PhD in International Commercial Arbitration and has over a decade of teaching experience. Dr. Yadav, sir, we warmly welcome you to take the stage.
Thank you so much. Very good afternoon to dignitaries on the dais, off the dais, and my student friends. It gives me an immense pleasure to welcome you all to this first technical session of the 4th International Symposium on Law and Peace. As we gather here to explore the future of legal education, we are standing at the crossroads of tradition and the innovation. As we embark on this important discussion, we are confronted with the profound transformation that are reshaping the landscape of legal education around the world. The legal profession, once relatively stable and predictable field, is now undergoing a rapid evolution. The dimension of legal education are expanding, driven by a number of forces such as technological innovations, advancements, globalization, rise of interdisciplinary approaches, and the heightened demand for social justice. The skills, knowledge that tomorrow's legal professionals need are very different from those that were taught just a few decades ago. As legal educators, practitioners, and students, we must ask ourselves how we can adapt to these changing times while maintaining the integrity and core values of the legal profession. In these changing and challenging times, the legal education demands an increased stress on advocacy skills, an active engagement of law students in pro bono work, policy development, and an engagement with works of NGOs which work for various causes such as human rights and environmental causes. In this first session, we will explore these challenging dimensions, focusing on how legal education is adapting to meet the demands of the modern and interconnected world, from integrating emerging technologies like artificial intelligence and data science, data analytics into legal practice, to rethinking traditional teaching methods. We are faced with new opportunities to prepare the students for an increasingly complex and dynamic world. Equally important is the shifting emphasis in legal education towards the diversity, inclusivity, and the need for lawyers to not only possess technical expertise, but also to equip with the ability to solve societal challenges. How do we balance the need for foundational legal knowledge with the demand for real-world skills, ethical awareness, and cultural competence? The session will provide a platform for dialogue and reflection on the essential changes in legal education. We hope to spark ideas and discussion that will help us better navigate the evolving landscape and ensure that future generations of legal professions are both competent and compassionate. As Madam Sane had just mentioned, that we need to brace ourselves for the technological innovations that are happening. The Western universities, which are well known in the legal domain, such as Yale University and Harvard University, have already taken their strides forward. It is we, the Indian legal academia, that we need to follow the steps and take a lead in bracing ourselves for this technological innovations that is approaching us. I hope each one of you will leave today with a deeper understanding of direction legal education is headed to, and the role we all play in this transformation. Once again, welcome you all to this first session of 4th ISLP. Let us look forward to a day thought-provoking discussion, a day full of thought-provoking discussion, shared insights and collaborative ideas that will shape the future and legal education. Without a further ado, now I hand over the proceedings to the guest speakers whom we all are eager to listen to. Thank you.
Thank you, sir. It is a great honor and privilege to introduce a towering figure in the field of labor laws, industrial relation, and legal consultancy, whose illustrious career spans nearly 3 decades of unparalleled expertise and contribution. Respected Dr. Shrikant Malegaonkar, sir. Dr. Shrikant's professional journey began with a deep commitment to the law, earning the prestigious Setalvad Prize from the Bar Council of Maharashtra. Over the past 28 years, Dr. Malegaonkar has established himself as a legal luminary, practicing at the Pune Labour Industrial Court and the Bombay High Court. As the founder of Malegaonkar and Association, his consultancy has become a trusted partner for some of the world's leading organizations, including Mercedes, Amazon, Coca-Cola, Philips, and list goes on. Dr. Shrikant is globally recognized speaker, having delivered lectures at prestigious institutions as London School of Economics, the School of Oriental African, and has conducted over 1,500 training workshops for industry giants such as Volkswagen, Fiat, Palaji, Phoenix, and many others. Please join me in extending a warm welcome to Dr. Shrikant Malegaonkar, sir, as he shares his opening remarks.
Respected dignitaries on the dais, Principal Madam, my dear friends. I'm here to talk on changing dimensions of legal education. What is legal education today? What it ought to be? What it could be tomorrow? How we stand today? What are the challenges and what could be the solutions? In whatever is the time available to me, I will try to cover and encompass all of them and comprehend it in whatever words possible. I am very infamous for belaboring a point, and I'll keep in mind that my time is some 10-12 minutes in which I have to sum up the total thing. Then we are going to have a group discussion. I'm a law student since almost 30 years. Teaching law as a visiting faculty for some 32 years. Almost 70,000 students interacted with most of them. Today interns come to my office, and this full spectrum gives me some food to my mind as to how the legal education is and how the legal education ought to be. Basically, friends, what is education? When Professor Ayush Mishra called me and he said, "Sir, you have to talk on this topic," my mind started mulling on it as to what am I to talk. And then I thought with myself that yes, it could be a churn of whatever 30 years of humble legal practice I have put in, and whatever interactions with students and whatever I have taught in India as well as abroad, and what could be the legal education and what is the need of the hour. So friends, in few words, I'm going to just encompass all of this. First and foremost, what is education itself? Education, people have tried to define education. But what I liked is the most favorite definition you can say, which I liked. Education is that which discloses to the wise. Education is that which discloses to the wise and disguises from the foolish his lack of understanding. That is education. Coming down to law, we are speaking of legal education, and then the topic here displays changing dimensions of legal education. So what is legal education? Students come to law college. Why do they come to law college? Students basically come to law college, and that is why if we see this total scenario, to sum it up in a few words or in a few minutes, it's not possible. But then if we see it's a multi-pronged approach. First and foremost, when we saw as to what is education, we also see as to people come to law colleges with the sole object of having a law degree. And when I was in college, I was told that a law degree is an evergreen degree and it has got so many uses. But basically, students of law who come here, the degree is twofold. Some of y'all are going to go into jobs. Somebody is going to go in government, become a judge or this and that. Somebody is going to go in the private sector. Somebody is going to go in the corporate world. And then there could be other avenues also. Somebody might could take up teaching, this and that. So on the one hand, we are having jobs which are available. Secondly, we are having legal education so that we produce lawyers. And being a science student, I always like to classify things. The second classification is, lawyers are again divided as per levels. Some are going to practice at some taluka, some at the district place, some at the High Court, some at the Supreme Court. And again there is a specialization. Somebody is going to practice into consumer law, and some into family law, and some into employment law, and this and that. But this is the basic distinction which we have. And how do we stand today? How we stand today is a matter to think about, that what are the skills required. The skills, friends, which are required basically are, one is litigation, or rather I would again reclassify it. Skills which are required by law students are of two types. One are seen skills and one are unseen skills which are never taught at law college. What would make students successful? I would wish each and every student who is sitting in front of me have their success, climb the crest of success today, tomorrow. That scaling should go on. But the thing is, what skills are required, and we have to see whether the legal education caters to those skills. And if it doesn't cater, we have to add those skills to the legal education, and that would be the changing the face of the legal education tomorrow. So what skills are required is, number one is research, second is litigation, and third is worldly knowledge. Research, as madam said, has become easy. I wouldn't say it's simple. It requires hard work. But in research, you are having so many service providers, whether it's Manupatra or SCC Online and this and that, and ultimately with a few words, and all these companies have come up with so many lucrative packages that you just give the name of the judge and the judgment is in front of you. It's all there. Technological advances are there. Today, AI is also there. With artificial intelligence, things are going to be much more easier. And then they say that they are going to add to artificial intelligence, and this is going to take care of the research. Madam also mentioned in her speech that tomorrow could be a time where when we feed all the judgments, and AI is going to deliver us the judgment that these are the facts and this could be the judgment. The question for all of us to ponder is that even if 1,000 computers are involved, it will not do the work of a single judge who knows as to what it feels and who knows what is an emotion. Secondly, what we see is the skills which are involved is litigation skills. I am here to speak on changing dimensions of legal education. No doubt, your syllabus is concrete. All those subjects are there. I am also informed that management subjects are taught in the first 2 years. But basically in litigation, what is required is, number one is oratory. Oratory is not taught at law college. English at some places is taught. And English is neither your mother tongue and it's neither my mother tongue. But the judgments are in English. We are ruled by the British. Books, 90% of them are in English. And then there are so many other things required in litigation as skills. Say, for example, strategic planning is there. Then there is planning also. Then there is proper thinking also. Then there is proper framing also. Then there is conceptualization also. Then there is a proper perspective you put the facts, for which some experience, hands-on experience is needed. And the third thing, friends, which is not taught at law college but is very essential, is worldly-wise knowledge skills. That is, all your soft skills are required, which again are not taught at law college. When I was in your class, I used to feel that somebody should teach me this, somebody should teach me time management, somebody should teach me marketing, somebody should teach me selling, somebody should teach me what is conflict management, somebody should teach me what is stress management. Madam mentioned, or I mean, they introduced me so many companies. In one company there is a strike, Mercedes this thing is going on, Volkswagen this thing is going on. If I am to take this stress, today should be the last day of my well-being on earth. I should die by evening. So much is the stress involved. Every lawyer will go through such stresses and strains, so you have to know how to handle stress also. That nerve building is there. And on the first day of my practice, somebody told me that there is a strike in such and such a company, I possibly would have fainted in my chair. Today, if somebody tells me that there is a strike in such a company, I tell him, okay, I'm having a meeting with somebody, don't waste my time. We'll look after that. It's not that it's not important. But then this digestion or this nerve building is over the years, which is not taught at law schools. I also said all law students, there are so many of the interns who come in my office. Then there are some unseen skills which everybody should possess. And what are those unseen skills? First is observation. How much can a senior teach you? How much can you see from the system? Nobody is going to teach you. And for which one has to be a bit worldly wise. And I remember that there are two skills my professors told me are very important to become successful. That is, one is selling skills and one are people skills. You may be having, or you stood first and you have the best marks and 90 and whatnot percentages people get today. And you are the most intelligent person in college, but if you don't know how to behave with people, you are the biggest failure the bar would ever see. Your people skills should be very good. You should know how to talk with the judge. You should know how to address the judge. You should know how to talk with colleagues. You should know how to talk with friends. And finally, you should know how to talk with clients. Whether you inspire confidence in the client. Why should he give you the brief? Is the basic question. And selling skills are very important. Have you ever thought that selling skills everybody requires? What is your teacher doing when she is teaching you in a class? She is selling. What is a politician doing when he asks for your votes? He is selling himself. What is a lawyer doing when he argues a case in court? Again, he is selling himself. And giving you a very simple example, what were you doing at the bus stop? When you were wearing your best shirt and your best tie and the best outfit and the best shoes and a beautiful mobile and trying to impress your girlfriend, what were you doing at that point of time? You were selling yourself. Selling skills are very important. One should know selling skills, second is people skill. And the question is, are all of these things taught? At college, answer is no. This is something unseen. Observation still is unseen. But everybody has to. If you are masters at that, see, whatever are your sections, I don't know what is section 302 IPC, I can read it and read it and reread it and reread it, and practice makes the master. And one day I got it, yes, this is what. But then the people skills and soft skills are something. As I told you, my teaching experience is very humble, something 32 years and 7 months as a visiting faculty, but which gave me some sort of a spectrum as to understand students. But then what I understood is, say, still remember, the term used to begin on 1st of July. Let's take any subject. Say, for example, Madam mentioned employment law. Employment law on 1st of July, students come to college, greet each other, then there is an induction program and you get new friends. And on 1st of July, any subject, your knowledge in that subject is 0%. And then you start studying the subject. And after 2.5 months, the term is over. At that point of time, July is over, August is over, mid-September term gets over. And at mid-September, every student is supposed to know 100% of the subject. Simple question, is this possible? And the answer is still simple, that this is a simple no. So what college is going to do is, they are going to just make you taste something, that's it. That's not the food, it's only a taste. If you have a pickle, you just taste it, that's it. That's what is college. Rest of the education is self-education itself, which students have to indulge in, if at all they have to be masters. Then I read about Mr. Jerome and Alexander Lubinsky, who introduced clinical legal education. Clinical, I told you, so many interns come to my office. Clinical legal education, yes, you be with a lawyer, and then you will learn all the skills. Is it? No. A person doesn't learn all these skills this way. You have to observe unseen skills. How does he talk? How does he talk to clients? How does he control himself? How does he control his anger? How does he control his stress? Are all the things which are not taught at law college. But they make you a good lawyer. So where are you going to learn all of these things? Then friends, what we see is clinical legal education. What do students do? See, interest comes by taking interest. The lawyer will get interested in you, your senior will get interested in you depending on how much you are interested in his work. It's a reciprocation. And he understands only a good disciple gets a good guru, and only a good guru gets a good disciple. Remember this equation. And you have to fit in both. And while you are studying this, you are interning with somebody, these are all the skills. He does not have time to come and teach you 1:1. But then something is to be taught. I remember both of my sons at Malegaonkar and advocates, they are lawyers. And I make it a point. In the evening, my son asks me that I argued it this way, and I differ with him. Then he differs with me. Then I differ with him, and then there is a big fight. My wife many a times thinks that today is the last day of our family and tomorrow it's going to be a broken family. No, I purposely do it. They don't know. I purposely get defeated while they argue with me because I understand that some defeats are more triumphant than victories. They outwit me, they outdebate me, they outmaneuver me, and I am lost. But I make it a point he fights with me. It's this skill which makes him a good lawyer. And this is what is for everybody to understand how we do it. Second is tomorrow, Gurukul system, whatever the world has, India has already provided. While I was walking through this corridor, I saw a statue of Charles Darwin. I remember having visited Oxford, wherein Charles Darwin, survival of the fittest. And then next to him is Chanakya's statue also I saw. And then I saw Charak also. All these are Indian luminaries who have given something to the world. And there is one more thing which India has given to the world, which all law students should understand. That would be the changing the face of the legal education tomorrow. And that is the Gurukul system. In whatever my study abroad, there used to be one professor and there used to be 10, 12 students. And we used to breathe with him and he used to talk law and he used to smell law and he used to just see law and everything is law only. That makes up a legal mind. There are limitations everywhere. India is having 142 crores of population. Teachers are limited. How many teachers and how many students is a ratio, and it should also be a manageable one. All those things, yes, problems would be there. I understand that problems would be there, but then what we see is that this Gurukul system is very important. I used to go with my professor for movies, and in the movies, again, what we talk is law. Then we used to go to a restaurant, and again at the restaurant, what we talk is law itself, and it's law and law and law, which I do with my sons even today. Yesterday evening, I went at the dinner table. My wife fights with me. Why are you talking law with him right now? But then, somewhere the lawyer comes in, somewhere the father comes out, somewhere the senior comes out of you, and this is what is to be taught to the younger generation. Why I am telling you is that yes, and one more thing what I feel is, in order to change the face of the legal education, this is not with you students, but it is with the Bar Council, that there ought to be an exam after every 5 years. Lawyers who have practiced for so many years don't know what are the settled judgments. How many of you, come on, let us be very honest and tell me, how many of you have read line to line and word to word Keshwananda Bharati versus Union of India, which enlightens you as far as the basic feature doctrine? How many of you have read Bangalore Water Works and Sewerage Board versus Rajappa? There are n number of judgments. So, one has to visit those judgments, one has to understand those judgments in the proper perspective. Otherwise, you go to a college, then you go to a senior. After 3 months, you become friendly with the senior, and then you tell him that my teacher has asked me for a certificate, and then the senior is also more than happy to give you a certificate that he is the best junior and the best intern ever seen on earth and who ever lived on earth. And then you take that and then you show it to 7 people, and then with the hope that you are going to get something good. It's one part of the story. That doesn't make you great. Greatness is achieved by you yourself. And then one more thing, suppose if I go to one teacher and he teaches me, how much can he teach me? He's got his own limitations. Then what I do is, I appoint 2 teachers, they teach me. Then I appoint 3 teachers, then 4 teachers, and you will say, then how much fees have I to give to 4 teachers? And if I tell you that, see, if 10 teachers, if they teach you, your knowledge will have some level. And if 30 teachers teach you, you will still be great. And then you are going to ask me, from where do I bring these 30 teachers? The answer is, everything is free. The best things in life, Mahatma Gandhi said, are the cheapest. And everything is available in this phone. You just open up a YouTube, which I do it today also. Some concept of law. On this, what are people saying? So you will get so many contributors, they are your teachers. Listen to what because he studied that. He's put in work hours, he's put in man hours, done with the dint of the hard work, he's ultimately produced a video. Listen to that video, what he says. Then the next one, your school teacher, college teacher, they are your teachers. You yourself are your second teacher, and plus you have these 30 teachers. You take it from me, the concepts will be very, very clear. We have a YouTube channel. On every aspect of labor law, we have videos, which of course I have produced. And then it makes it very simple, and sometimes, of course, it's fun to meet somebody and he tells you, are you so and so? Yes, I have seen your video. It helped me in exam. It helped me this way, that way. Come on, that's your contribution. But the thing is, the best things in life are the cheapest. I would not subscribe to the theory that don't look at YouTube or don't see movies which have a bearing on your subject. No, these are all, a lawyer should take knowledge from wherever he gets in talking with people. And lastly, I told you, these soft skills, people skills are very important. You are the best person on earth, but if your appearance is, I may be the best lawyer on earth, but if my appearance is the worst, I am the worst lawyer on earth. Vice versa, I may be the worst person on earth, but if my appearance is good, yes. So what is with me? It's a parasitic idea. It's all with the other person. But then you have to be good also. You have to work hard also. You have to work smart also. And the debate between them is already over. Then you have AI also, and then you have YouTube also. See, so many teachers. Things are so simple. Let me tell you, 30 years ago when I started practice, it was very difficult and very difficult. I'm the first generation lawyer. My condition was still difficult. Whether I should be a lawyer or not, there was a big furor in my house. And people gave different examples because there is nothing forward to look with hope and nothing backward to look with pride. But in this might be the story of some of you sitting here. I'm not saying each and every one, but then don't lose hope. Today's time is the best time ever on earth for a law practice. Have you ever thought that once upon a time there was an MBA boom? Everywhere, everybody is doing MBA and DBM and this in my days. So there were so many MBA institutes which came up. There was a mushrooming of them. Then do you know what happened? When Sam Pitroda, the technical advisor of Rajiv Gandhi, and Rajiv Gandhi came into power, they brought in computerization. Then came a computer boom. And then so many courses, computer engineering and BCS and MCS and MSc IT, so many of them. All typewriting institutes are converted into computer institutes. Have you ever thought of that? So the first wave was the MBA boom. Second one was the computer boom. Do you know what is the third wave now coming? Or the third boom is what? The third boom is the law boom. And you should be prepared for it. I represent so many multinational companies. There's Coca-Cola and this and Amazon and whatnot, madam just mentioned. And then the one who introduced me. Have you ever thought all these multinationals are coming to India? They are coming with lots of money. Yes. And they want somebody who's going to deliver the goods. And one day I asked them, what is the difference between good Indians and bad Indians? And one of the managing directors told me that there is a difference between good and bad Indians. The difficulty is both look the same. From the face you cannot make out he's a good or a bad Indian. He presents me a paper which is called as a degree and then says you believe in me. Should he believe in you? All these skills are required. Of course, laws go on changing. Tomorrow there is another law, Bharatiya Nyaya Sanhita, that is also there. Legislature is going to frame, you should know that. Theory is important. I will not relegate theory to a lower position, but then all of the other things, together it's going to make you a good lawyer. Now all these things have to be blended in your syllabus. I don't know how they are going to do it because then there are Bar Council regulations. I myself was on the Board of Studies of Pune University. We introduced so many things into the syllabus, and I still remember we introduced 2 movies also, that if you want to understand labor law, you have to see this movie. 90% you will understand. All film stars, Pankaj Kapoor and Sadashiv Amrapurkar and this and that, is entertaining also, and you learn also. And this should be a habit day in and day out, which will make people successful, which will make great lawyers out of you, all of you all sitting in. I wish everybody all the best, but then the dimensions of law have to be changed. All these changes have to be brought in. And I would like to congratulate your college also because management is already introduced in the first 2 years. This is the only college, I believe, which has management subject, organizational behavior. I was asking sir, he said human resource management, right in the first year you all are having. So you have an edge over others also. But then this is not enough, and nothing is enough. So a disciplined approach, every day at least 2-3 videos concerning your subject you have to see. Your teachers are there to guide you, and this would be, so all these putting it into a blend. We are making suggestions to the Bar Council of India also, and maybe tomorrow it might see the light of the day. So this is going to change the Indian scenario and produce great lawyers, and even in other corporate jobs, people want good people, which you will be one of them. And you have been a great audience, and my time is getting limited. I told you I am infamous for belaboring a point, and you are people with great patience. Shakespeare said, how poor are they, those who have no patience? And here is a bunch of students who have abundance in patience, because whoever tolerates me is good at patience, is what my wife tells me. Okay, thank you so much. Thank you.
Thank you, sir. Your impactful insight, your contribution have added immense value to our symposium.
Our next speaker is Advocate Ranit Basu sir, a practicing advocate and partner at Bridgehead Law Partners. Beginning his legal journey in 2015 at Chambers of Senior Advocate B. Chatterjee, he has since been involved in high-stake cases across direct and indirect taxation, arbitration, insolvency, bankruptcy, security laws, and much more. An expert on the insolvency and bankruptcy code, Advocate Basu has established a strong practice assisting clients at every stage of the process, while also specializing in real estate, admiralty, and intellectual property rights. Regularly appearing before major tribunals and high courts across India, in 2019 he founded Bridgehead Law Partners, a full-service corporation and litigation firm serving Indian and international clients. We are very grateful for your presence, sir. Please join me in extending a warm welcome to our guest.
Very good afternoon to everybody present here. I know some of the faculties here, and I am extremely grateful for having received this invitation. Before I proceed with the topic or touch upon the topic, I would like to say that having heard the introductory speeches that has been provided by the college and my senior colleague and predecessor, it was not. And Dr. Malegaonkar, who's my senior colleague and who preceded me in this session. It reminds me of a seminar which was delivered on the 150th anniversary of the Bombay High Court, where the Bombay Bar Association had invited senior advocate Ram Jethmalani to give the inaugural speech. Before he came to the dais to start speaking on the legacy of the Bombay High Court, there were senior judges of the Supreme Court and the High Court who had delivered the lecture before him. So before coming and before he got to the topic, the first thing that he said is that being the sixth speaker of this panel, I feel like the sixth husband of Elizabeth Taylor. On the day Elizabeth Taylor and her husband was about to get married, he was very nervous. And so his friends asked him, what is it that is making you so jittery? To which he replied that, tonight I know exactly what to do, but I don't know how to do it differently. Having heard Dr. Malegaonkar speak about a wide range of topics, I feel the same today because I know what is to be spoken and how it is to be spoken, but to encapsulate my mind after what has been said is extremely difficult, but I'll still try to do justice to the session in the best possible way in sharing what I have learned in my limited exposure. In fact, it was only 9 years back that I have passed out just 2 blocks away from this college, from Bharati Vidyapeeth. So technically, I am a sort of your neighbor at one point of time. In my limited experience of 9.5 years practicing in the Bombay High Court, what I have learned right now is that there are various drastic changes which are taking place in the legal fraternity. People are becoming extremely erratic with regards to the choices that they make. Over the 5 years period, whatever decisions they take with regards to how they want to shape up their future, that gets eradicated even within 6 months, within 6 months of them practicing law. In fact, in the inaugural speech of Justice Khanna, he had lamented that a lot of people are losing practice in litigation, are losing practice with regards to the flair and the excitement that the legal profession brings. And therefore, it is important for the law schools, senior colleagues, and everyone to ensure that new people keep coming in and quality is added within the legal profession on each day. And therefore, it is very important that whether or not a particular person wants to practice law and what field of law he or she chooses to practice, that gets inculcated during the law school itself. for inculcating that, because when we were there at that point of time in 2010, when I joined the law school, at that point of time, apart from what is provided in the syllabus, one of the best ways to learn how to, the practical applications of various legislatures was to participate in moot court competitions. And I think moot court competitions play a pivotal role in ensuring that a law student gets practical exposure towards it. When I was a law student in my 5 years, I have participated in 10 moot court competitions across the country. In each competition, I have qualified till the at least till the semi-final level, but never won a single competitions. So at that point of time, at that relevant point of time, I was probably the most successful failure in the mooting fraternity at that point of time. But I still think, in spite of failing in all those 10 occasions, but still I believe that at that point of time, the exposure that I got, when you go for 2-3 days to a different state in a completely different environment and get to interact with people from different parts of the country, it gives you the sort of exposure that helps in building your confidence in a large manner. So I think in every way, moot court competitions are one aspect, although you cannot really compare the experience of mooting with the real world advocacy, but that is one aspect which allows you to go out from your set syllabus and go and start perusing commentaries, and that in a way helps you to actually decide whether or not this particular subject is of interest to me or not. And therefore, I would definitely vehemently encourage all of you to participate in moot court competitions as much as possible. In fact, in addition to that, I think some of the experiences that I have felt is that in 2015, when I passed out, at that point of time, the legislation, the legal community was under a lot of stress with regards to completely tackling the issue of pendency of cases. And therefore, in order to tackle the pendency of cases, gradually legislation started coming up and constitution of tribunal started happening. In 2016, the National Company Law Tribunal was constituted. The special legislation of Insolvency Bankruptcy Court happened. And then the RERA Appellate Tribunal happened. Of late, very recently, the Central Goods and Service Tax Appellate Tribunals have come in. So I am sure a lot of you must have heard from your relatives, your friends, and everybody that there is a lot of gestation period in the practice of law. So initial 10 years, a lot of struggle is undertaken by everybody, and the earnings are extremely low. Due to the advent of tribunals, the gestation period to a large extent has been minimized. A lot of young lawyers are able to gain exposure of arguments in various tribunals and argue high-stake matters which concern crores, if not crores, at least lakhs of rupees. So tribunal practice is something that every law student should definitely try and see. In fact, during your internships, I would encourage every one of you to join law firms or advocates who have a lot of, experience with regards to practicing in various tribunals and gain that exposure. In addition to that, I think one of the fields which has become extremely lucrative at these stages is arbitration law. And arbitration law is something which is picking up because the courts are unable to tackle the large stake matters. And the domestic as well as international arbitration practice is something which requires you, it may look very lucrative because the entire setting is in the 5-star hotel in a conference room where you have to sit, have extremely good lunch and everything. But the reality is that in order to succeed in arbitration, you also need to have subject matter expertise on various fields. How the commerce of a specific industry runs, how the financials are dealt with, how are the books maintained, because there are various issues, allegations, cross allegations with regards to the financial manipulation which are made between parties, and therefore having first-hand knowledge of how to read a balance sheet, what is a ledger, how the details of expenditure, details of earnings are maintained by a company is extremely important to know. In addition to that, there are various different types of arbitrations, like arbitration related to oil and natural gas, arbitration related to tenders, which is given by the government to the private party, and therefore having knowledge of all these aspects is extremely important. So a holistic understanding of various branches of law for a specific mandate is what is attributable at this point of time. And I believe that these aspects can actually help you broaden your scope in practice in a very large way. In addition to that, what has been stated at every point of time is that by Dr. Malegaonkar, as well as the opening remarks made, is that there is a changing field. But in order to understand the changing field, you need to understand, you need to know the basics from which the entire issues have evolved. So, as Dr. Malegaonkar has said, that it is important for you to read important judgments like Keshav Nanda Bharti, S.R. Bommai. But I believe that if every one of you take his advice seriously, then half of you might end up quitting law also, and the college itself might face a lot of financial distress, because those are spanning 600 pages. One of the easier ways of learning and inculcating these things is reading various books by jurists. One book that I would suggest, which has in brief given details of various landmark judgments, is a book called Courtroom Genius. Courtroom Genius deals with the legal journey of Dani Palkiwala. It is written by Soli Sorabji and Arvind Datar. When I read that book, I understood that as a lawyer, the kind of impact that one can make, why bank nationalization case is important for the larger finance, and it holds relevance even today. Why Minerva Mills is something which concerns a wide spectrum of laws, and it is important to understand the ratio. Ratio is the logic laid down in those judgments. T.N. Seshan versus Union of India speaks about electoral independence. Right now, there are allegations, cross allegations with regards to how elections are conducted. The practical manner in which a lawyer has to understand those aspects is encapsulated in that book itself, by virtue of those case laws. Why basic structure is absolutely important. Why ADM Jabalpur, which deals with Article 21 and Article 14, has significance even today also. The ratio laid down, subsequently overturned, and all the aspects, why Justice H.R. Khanna and his dissenting judgment has a significance in everyday life, and it will continue to have significance in everyday life, is also something which is encapsulated in that book also. And therefore, I think by the time every one of you start reading a book like Courtroom Genius, and by the time you end reading such a book, you will be completely transformed from one person to another person. I would strongly suggest that you go through it. In addition to that, the concept of jurisprudence, which is very essential for a lawyer to inculcate in his life, that it is very important to understand how it is applied in everyday life. Today we see altercations. I'm sure you must have seen altercation of Supreme Court judges with certain advocates who were trying to disrupt the proceedings in the court and trying to push matters push their own matters forward. In order to understand how Supreme Court functions, or in that sense how a writ court functions, whether it is the Bombay High Court, whether it is any High Court exercising its powers under 226, or it's the Apex Court which is involved in discharging its constitutional duties. In order to understand it, what you need to understand are the basic manner in which the Constitution in general, whether it is Indian constitution or a constitution in general, is required to be interpreted. For that, the one book that I would definitely suggest to all of you is The Essentials of Scalia. Justice Antonin Scalia was a Supreme Court, was a judge of the Supreme Court of the United States of America. He has propounded the theory of living constitution. Whether a particular court or particular legislation is at liberty to twist what has been stated in the constitution as per their own ideologies or whims and fancies, that has been very categorically stated. What he has strongly stated is that the constitution, irrespective of its original structure, has to be interpreted in a manner which the original makers of the constitution had propounded. So therefore, I would really request you, what I think from my own personal understanding is that request you to also go back to the basics while trying to adapt to the changes in the recent times, which is obviously moving at a breakneck pace, and everybody requires to catch up with it in an effective manner. That is one aspect which I would like to tell you. In addition to all these aspects, I think there are certain, as far as the, I think AI is something which was very strongly advocated at various point of time. I believe that at one point, I would share my personal experience with regards to artificial intelligence. Whenever we hire any associate in our law firm, we request for them to send your CV to us. When they send their CV to us and we like the CV, we send them a questionnaire. When we send them a questionnaire, there are a few general questions in those questionnaire. What are the field of law that you are interested in? What are the various case laws that you have read? How do you see progressing in career with regards to a specific scope of work? And there are certain people who have come very well, who have enumerated their likings, dislikes, their focus very well in those questionnaires. On that basis, we shortlist them and we interview them. Within 5 minutes of the interview, it becomes very clear that the source of their liking and disliking, the source is actually ChatGPT. Everything that they have actually put in those questionnaires is through ChatGPT or through AI. Therefore, I would request that dependence on AI can actually have a crippling effect on everybody in general. So it is one thing, it is obviously something which makes your work efficient, but please do not find it as a tool or an apparatus as a substitute to your hard work or to your learning. The process of learning cannot be substituted by way of artificial intelligence. Obviously, we need to learn. It is evolving as I speak right now. But still, the basic manner in which a specific law has to be looked into is something that you always have to learn. In addition to that, there are other aspects which I say is that when you approach a specific subject of law or a specific court of law, in the High Court, or if you are approaching trials are very broad in nature, where the entire evidence takes place and you have to establish your claim effectively. And if you are going before a tribunal, every tribunal is a summary trial where summary proceedings take place. Or if there is a summary suit under Order 30 or 39 or Order 37 of the Civil Procedure Code, at that point of time, you have to be elastic enough to modify your approach with regards to every aspect of law that you face and accordingly proceed ahead. In my recent years, what I have seen is that as junior lawyers, there is a lot of scope in getting matters where you can appear for the Child Welfare Commission, who work tirelessly in ensuring that child trafficking and girl trafficking is curtailed in an effective manner. These are matters in which establish a relationship with child welfare committee and try to assist them in effective manner, then they will give you opportunities to appear and protect the interest of the society at large. So these are some of the aspects that I think you should effectively look into. Another aspect is that right now, I believe that the profession at large is becoming extremely overcrowded. Therefore, it is important that you develop a subject matter expertise in the new and transforming subjects of law. For example, if it is IPR, whether it is commercial disputes, there are various issues emanating out of securities law. The securities fraud has become extremely rampant, and especially just 200 kilometers away from Pune, in Mumbai, we have the Securities Appellate Tribunal. Securities Appellate Tribunal is a very good platform, a very good court for anybody to start practicing with respect to securities law, as if you target specific fields of law, it will become easy for everyone to penetrate and carve a niche for yourself. These are certain aspects which I believe will play a pivotal role, and I hope everything that has been said will help you in effective manner. I thank you for your time and patience.
We have now arrived at the end of this session. The resolution in light of the speeches by our panel members and discussions carried out today. I shall now read out our resolution. Please stand up, raise your hands, and respond at the end with an I affirm. I request you all to please stand up, raise your hands. We, the participants of the 4th International Symposium on Law and Peace, solemnly affirm that I shall adapt to equip myself with not only the foundational legal language, but also the skills and competencies required for the 21st century, including critical thinking, interdisciplinary learning, technology literacy, and ethical judgment. I promise to prioritize ethics and professional responsibility as core components of legal education, and to be prepared to navigate complex ethical dilemmas arising from technological advancements, global connectivity, and evolving societal values. Please respond by saying I affirm.
I affirm. Thank you, everyone. You may be seated. I now request everyone to be kindly seated, please. As we approach the conclusion of this insightful session, we express our gratitude to everyone who has contributed to its success. To formally extend our heartfelt thanks and conclude this session, a memorable note, I now invite Associate Dean Professor Parimal Sudhakar Sir from MIT World Peace University, School of Government, to deliver the vote of thanks.
Thank you. It is indeed my pleasure and honor to deliver this vote of thanks in the session of the 4th International Symposium on Law and Peace. At the outset, dear students, let me express my gratitude on behalf of the organizers for all of you who have been sitting here very patiently and listening to the wise words of today's guests in this particular session. Without your presence here and without your willingness to listen to our guests, this particular session would not have been successful. I am thankful to both the guests of this session, Mr. Ranjit Basu, Advocate Ranjit Basu, and Advocate Dr. Shrikant Malegaonkar sir, for your valuable time that you have spent for our students, and most importantly, your words of wisdom for our students that have really enlightened us. For me particularly, this was one of the best counseling sessions that I have ever encountered. And I hope, dear students, all of you also must have learned a lot from what today's dignitaries have spoken to you. Advocate Ranjit Basu, sir, you have been an example of how, I know you are not a junior lawyer, but when you face a giant in the court and how you should put forward your your views and your opinions in front of the bench, and that's what you have done it so perfectly when Shrikant Malegaonkar sir have spoken. And when Shrikant Malegaonkar sir concluded, I also was wondering that now what Ranjit sir would speak. But certainly you have given so many good advices to our students. And something that I liked most was your advice to read good books. That would take our students a long way in any profession that they would choose, but particularly in the profession of law. Your advice to look at the system of tribunal practices, to the arbitration law, also to develop expertise because the field is getting overcrowded. That is also something that our students definitely would take it quite seriously. While you said that the field is getting overcrowded, but Shrikant Malegaonkar sir also said that this is the best time for the law students, as particularly said that today's time is the best time. There could be no better time than what we stand today also. After MBA boom, after computer boom, the law boom is there. That's what Shrikant Malegaonkar sir has told us. And Shrikant Malegaonkar sir's every sentence is something that certainly would help all of us, all of you, at some point of time in your career, during your studentship and then onwards as well. Shrikant Malegaonkar sir had begun by saying that he has been a student of law for more than 30 years or so. And that itself said so many things, that in the profession of law, you never cease to be a student. Something that he also further elaborated, that in this field, there has to be exam every 5 years. And sir, I think that certainly is quite important in this particular field, but in all the fields as well, because knowledge is developing, new practices are developing, new cases are turning up, and all of us really need to catch up with what's happening in the field. And therefore, this particular suggestion was certainly very important in this particular field. What you spoke on the seen skills and unseen skills. Sir, I think that particular aspect we are trying to develop in our university. That if you look at the tagline of our university, it is the only university for transformation of life. And we believe that students don't learn only in the classroom, but they also learn outside the classroom. Students don't learn only from their faculties, but they also learn through the co-creation activities. Students learn much more among themselves than what they learn from their faculties. And we also believe that we as a faculty also learn a lot from our students. And that's the unseen skill that I think is very important that you have spoken about. So once again, thank you so much, Shrikant Malegaonkar sir and Ranjit Basu sir, for your guidance to our students. My heartfelt thanks to the organizers for organizing this symposium, and also to our Executive President Rahul V. Karad sir for providing this wonderful platform, wherein the jurists, the experts in the field, regularly they are coming to the university and interacting with our students, which is very essential for our students to open up the mind, to think about what kind of career they could build, and also provide them a lot of opportunities in the future. So once again, with these words, sir, I express my gratitude and declare that this session is concluded. Thank you.
Thank you, sir. Thank you all for being a wonderful audience. We shall now proceed to the next session of the symposium.
I would like to request you all to remain seated in your seats. We would begin our next session immediately.
Respected dignitaries, distinguished guests, faculty members, and dear students. I am Ananya Sinha from 2nd year BBA LLB.
And I am Sakshi Lange from 5th year BBA LLB.
And we will be your anchors for the session. It is an honor to welcome you to the second session of the 4th International Symposium on Law and Peace. We are thrilled to have you join us today. Let's make this a memorable and enriching experience together.
As we begin this important event, let us take a moment to reflect on the inspiring journey of Dr. Vishwanath Karad, MIT World Peace University, built on the values of education, research, and peace. MIT World Peace University has over the past 4 decades grown into India's one of the most leading institutions. With alumni spread across the globe, it is known for its commitment to excellence and holistic growth. Today, as we come together for this symposium, we aim to create a space for meaningful discussions, exchange of ideas, and lasting inspiration.
Our theme for the second session on the 4th International Symposium on Law and Peace is Advancing Human Rights and Peace, Building a Resilient Future. Advancing human rights and peace is essential for building a resilient and sustainable future. Protecting human rights ensures dignity, equality, and justice, fostering inclusive and empowered communities. A resilient future depends on unity, compassion, and commitment to human rights and lasting peace. This session explores the critical role of human rights and peace building in creating a resilient and sustainable future. It is my pleasure to welcome our esteemed panel of experts who will guide us through this important discussion on advancing human rights, fostering peace, and building a resilient future. With their diverse perspectives and wealth of experience, we are in for an insightful and thought-provoking session.
Please join me in welcoming our distinguished panel. I would now request our Dr. Dhanashri Tharkude ma'am to please felicitate Dr. Ujjwala Bandale ma'am, Dean, Faculty of Law, Bharati Vidyapeeth.
You were saying it?
Dr. Vishal Gulina,
Dean of School of Liberal Arts.
Can we have a huge round of applause, guys? I would now request Dr. Vishal Gole, Dean of Liberal Arts, MIT World Peace University, to please felicitate Advocate Sumir Sodhi Sir, Advocate on Record, Supreme Court of India. I would request everyone to cheer up for the felicitation.
Thank you, sir. I would now request Dr. Dhanashri Tharkure ma'am, Associate Dean for External Relations, MIT World Peace University's Ramcharan School of Leadership, to felicitate Advocate Rachana Reddy ma'am, Senior Advocate.
Round of applause for ma'am.
I would now request Dr. Vishal Ghule sir, Dean of School of Liberal Arts, MIT World Peace University, to felicitate Advocate Pratik Rajopadhyay sir, Managing Partner of Tavish Law Associates.
Moving forward, I would request all the panelists to stand at the front of the stage for a group photograph. Kindly, media team, can we have a group photograph? I would request all the panelists to take the picture with the brochure.
Thank you so much. To officially commence today's event, it is my privilege to introduce Dr. Vishal Ghule sir, Dean of School of Liberal Arts, MIT World Peace University, and request him to deliver the welcome address.
Esteemed panel, delegates and senior lawyers, all the faculty members of law school and dear students. This is a more than pleasure to be here today. As you know, I belongs to School of Liberal Arts. Other than seeing lawyers arguing in the court, I do not have any relation with lawyers. But then would like to understand more, especially from the perspective of human rights, because as a psychologist, I know what difference it makes when a country or a society has concerns about human rights. We have, as a psychologist, I always have this perspective of how as a society, as a country, as a culture, we are different than the current other cultures and countries that we have in the world. Recently, I was traveling through the Gulf countries, and I realized that, especially if you have been to Dubai, it's all very fancy. It's all very nice, and it's really good. But then I was observing, as we are trained to observe things as a psychologist. This is our profession. I was observing people, and I realized that there's something missing. There's something off. It is all very fancy, rich, and really nice. Everything is really nice. But still, I was not feeling like the way we feel here in Pune. And then I was discussing with my fellow travelers and faculty members, and then we realized that somewhat people are not open. Somewhat people are not ready to speak. Somewhat people are not, somewhere there is something missing, and that something is the freedom that we have here. There's the other side of this thing is, we are also taking disadvantage of that freedom that we realize, especially when you drive. Especially when we drive in Pune, and I was, yesterday I was, while going home, there was a biker who was like showing some skills on the road, and I got irritated and I started honking. And then I realized that the same thing, similar kind of thing I saw there, and people were so patient that they waited and let the pedestrian and other people walk, and without any signal, people were following certain rules. And again, psychologist in me asked me this question, that is it people are so sorted there? that they are disciplined and they're following rules, or what it is, and can't we do that? Now, I don't want to answer this question. I want to keep it open, and I want all of us to reflect that we cannot achieve peace unless we also consider looking inside. To achieve the peace, basically, peace and conflict, it's not, we don't only have the external factors to it. Earlier, the anchor were talking about unity, about compassion, about commitment. We also need to talk about motives. We also need to talk about emotions that are there in it. I know this is a law symposium, and I have seen it in a lot of suspense thrillers, that when they investigate, they talk about what is the motive behind this. Right? Now, when we talk about human rights and peace, if we have to achieve it, we need to understand the motives that in certain places globally, that people are following it, and certain places people are not. So I'm sure in this session, you'll obviously get an opportunity to understand the legal side of it, understand the cultural, social aspect of it. Even with the different case laws and all, you'll be able to understand more about it. But I think it's my responsibility as a psychologist to talk about the human inner conflict that we all are going through. And at the same time, we need to understand the motives and emotion behind it. Just an effort to make you think about it. Thank you for inviting me here, and I would like to welcome all the senior council here in MIT, and MIT being one of the oldest educational institute in this part of country, we always have this effort to make sure that our students should get something extra other than their curriculum, and this is the effort, and we are looking forward in that direction. Again, welcome you all, and thank you for this opportunity.
Thank you, sir.
I would now request our technical team to play a short video for us, which will give us the glimpse on today's panel discussion.
In our world today, the pursuit of peace is inseparable from the recognition and protection of human rights. But what happens when those rights are denied? The absence of peace is often a direct result of the violation of fundamental freedoms, the right to life, liberty, and security. When individuals are denied their dignity, equality, and basic entitlements, societies fracture. Conflict, fear, and suffering take root. But peace, true peace, is not simply the absence of war. It is the presence of justice, the assurance of safety, and the celebration of equality. Human rights are the foundation for peace building. They are the essential building blocks of a just and harmonious society, where people's rights are upheld, where every person, regardless of gender, is treated with respect. The path to sustainable peace is paved. The session will explore how gender justice intersects with human rights and peace building, examining how the violation of these rights fuels unrest and how their protection can create pathways to reconciliation and lasting peace. Together, we will critically examine the intrinsic relationship between human rights and peace, and how we can build a future where everyone thrives in dignity, freedom, and justice. Welcome to the session on human rights and peace.
I would now like to extend a warm welcome and cordially invite Professor Rushil Chandra Sir to set the motion for today's session and share his keen insights to add value to our discussions.
A very good afternoon to all the distinguished dignitaries on and off the dais, to all the esteemed panelists, esteemed faculty members, all the participants, and my dear students. It is an honor to moderate this pivotal session of the 4th International Symposium on Law and Peace organized by the School of Law, Dr. Vishwanath Karad, MIT World Peace University. This gathering stands as a testament to our collective commitment to fostering meaningful discourse on the theme of the session, that is, human rights and peace, with the motion being advancing human rights and peace, building a resilient future. Today we find ourselves in a rapidly evolving global landscape shaped by challenges such as climate change, social inequalities, migration crisis, and global geopolitical tensions. These issues test our resolve to protect human rights and maintain peace. However, they also present opportunities to innovate, collaborate, and strengthen our collective resilience. In this rapidly transforming global landscape where unprecedented challenges loom large, the protection and promotion of human rights are not mere ideas, but imperatives. Peace, often perceived as absence of conflict, is, in truth, the presence of justice, equality, and understanding. It is within this nexus that humanity strives to address the crises such as global growing inequality, forced migration, climate emergencies, and digital misinformation. Advancing human rights demands a commitment to the principles of equity and inclusion, ensuring that every voice is heard in every corner of the country and every life is valued. It requires courage to dismantle systems of oppression and innovation to establish frameworks of protection. Peace, in turn, is the bridge that enables principles to take roots and flourish. Together, they create a resilient future where societies adapt to the adversity and rebuild in the face of trials and emerge stronger and more united. The resilience of humanity lies in its ability to envision and realize such a future. Through dialogues, collaborations, and innovation, we can rise above these fractures of division and build a legacy of harmony for generations to come. Now, let us embrace this vision and inspire by unyielding hope that our collective actions today can shape a brighter future tomorrow. On that note, I would now invite the panelists to express their views. With that, I would end my speech.
Thank you for such a great insights on this session, sir.
It is indeed my honor and privilege to welcome our distinguished speaker for this session, Dr. Ujjwala Bendare ma'am. Dr. Bendare is a renowned academician and legal expert with an illustrious career spanning over 2 decades. She has pursued her academic profile with a PhD in property laws from Bharatiya Vidyapeeth Deemed University, Pune. Currently, she serves as the Dean of Faculty of Law at Bharatiya Vidyapeeth Deemed University, Pune, where she has also been an academic research guide since 2010, mentoring 8 PhD scholars, 6 of whom have successfully earned their doctorates under her guidance. Ma'am's exceptional contributions to legal education have been recognized with the Best Teacher Award in 2003, 2014, and 2015. Ma'am has been appointed as a legal expert for judicial service selection by both the Bihar Public Service Commission and the Rajasthan Public Service Commission. She is also a member of the Technical Advisory Committee of the International Longevity Center, India. On the international stage, Ma'am is a distinguished member of the International Council of Jurists, London. She has represented India at global forums and had the privilege of being a legal advisor to the Harvard Model United Nations in Boston, USA. Her remarkable journey as a scholar, educator, and legal expert is truly inspiring, and we are privileged to have her with us today. I now request Dr. Bendare ma'am to address the audience.
Good evening, everyone. Respected panelists over here and all the respected members of this university. First and foremost, let me congratulate each one of you and the organizers for having this symposium on human rights and peace. Basically, this is a much awaited topic to be talked about today, and in today's world and in today's situations, we really, as youngsters of tomorrow, we need to focus on what really is the worth of human values and human rights and the peace which we are enjoying today, the peace which we on this side of the world or the globe we are enjoying, and the peace which the other side is wanting for, is really what we need to focus upon. So, the topic today is advancing human rights and peace, building resilient future. Basically, human rights are what we all should be very clear about. I'm not very sure which year, which class students you all are, but let me tell you, basically, human rights are the fundamental basic right which we have inherited by our birth, which we have got it from the Almighty Himself. These basic rights are our fundamental rights. We call them as inherent rights. They are indivisible rights. They are the rights which are the most wanted rights for every individual who takes birth on this earth. And that is the reason why human rights and peace are hand in hand, and we can say they are interwoven. And when we talk about human rights, you all should understand the evolution of this human rights has its history right in the year you can talk about in 1818. And from then onwards, we see human rights talked about, but they never dealt in very rightly, and today are they violated. So, do you all know that there are 4 generations of human rights? The first generation of human rights are the civil and political human rights. The second generation human rights are the economic, social, cultural rights. And the third generation are the collective rights. And what are the 4th generation rights? Have you ever thought of? The 4th generation rights are your rights, the rights of this generation, and they are the technological rights which we understand in the name of cyber rights, or you can say IPR rights. And we all should understand that these are the rights which are going to curtail our peace more in the coming years. And that is the reason why, in the introductory note, let me take you towards an understanding of UDHR, ICCPR, and ICEACR. They are the conventions which started right from 1948. 1948, UDHR came up with giving us the concerns and 2 important facets of human rights, and they are equality and dignity. And when we talk about equality and dignity, we mean they are very significant for everyone, and every individual should have access to equality and dignity without any discrimination. Which discrimination are we talking about? Discrimination on the basis of race, color, sex, religion, political and other opinion, national or social origin, property, birth, and other status. These grounds are very clearly stated, and were clearly stated not only in UDHR, but also they are very clearly taken under our Part 3 of Indian Constitution. If you know fundamental rights are what are talking about the basic human rights of all our individuals. And then, when we talk about this particular rights, we need to specifically focus on the needs, which are to be more focusing on marginalized and disadvantaged groups across the world. And this is the responsibility on all the states to see that the focus should be on this marginalized and disadvantaged groups. And when we talk about peace, more emphasis should be given on the 2nd generation rights. I told you, 2nd generation rights are your economic, social, and cultural rights. This rights, if we focus upon, I'll tell you, this conflicts which we have, the struggle which we have, this particular unrest which we have continuously will be taken care of. So what are this? Social, economic, and particular cultural rights. Basically, the onus is on the state to see that access is given to every person on healthcare, on education, on working, or rather right to work, food. All these things are to be focused by the state. And if the state fails to focus on these specific rights, let me tell you what happens is continuous unrest, continuous violation of rights. There is continuous instability into the society. And when there is instability into the society, what prevails is violence, and there is breach of peace. And that is what we need to focus more upon. And that is the reason why I keep on telling that please focus upon mitigating the issues which are the outcome of the violation of the second generation rights. And wherever you go on this earth, totally the marginalized and disadvantaged group is totally, you can say, devoid of the specific right to education, right to work, right to food, and of course right to healthcare, right to housing. And that is the onus on all of us, the future generation, that we should focus upon. So basically, the key steps needed are threefold. What should we do? Locally, we should be seeing that the educational institutions and civil societies, the NGOs and medias, should spread education, should spread awareness continuously. At domestic level, that is national level, we should strengthen the legal and policy frameworks which we go on continuously signing. In the sense, when we talk about internationally, globally, we are signatories to many conventions. But when we are signatories to many conventions, when it comes to implementation, how many of us really implement? How many states do really implement? And the big 5 Ps, that is the permanent members, do they really have the particular significant applications or implementations of the particular conventional rights or other conventional agreements which they sign into? So we have to focus upon that at domestic level, and internationally we have to have cooperation amongst the states. If cooperation amongst the states are there at larger level, we can surely, according to United Nations Charter, we can think of having peace throughout the territory. And that is the reason why I'll just end my talk with a particular quote by Honorable APJ Abdul Kalam, which the quote I have taken from his The Righteous Life. And the quote is, "Where there is righteousness in the heart, there is beauty in the character. When there is beauty in the character, there is harmony in the home. When there is harmony in the home, there is order in the nation. And when there is order in the nation, there is peace in the world." Thank you, everyone.
Thank you so much, ma'am, for enlightening us on today's topic. We are truly looking forward to the session.
Moving forward, it is my privilege to introduce Advocate Sumir Sodhi Sir, Advocate on Record, Supreme Court of India, an accomplished legal luminary. With over 15 years of distinguished experience in the legal profession, Mr. Sodhi Sir has established himself as a prominent advocate practicing in Delhi. His journey of excellence began with achieving an All India Rank 2 in the highly competitive 2017 Advocate on Record examination, underscoring his exceptional legal acumen. Since 2009, Advocate Sodhi Sir has contributed significantly to the legal field, serving as standing counsel for the states of Chhattisgarh and Punjab. Currently, he holds the prestigious position of panel lawyer for the state of Jharkhand and represents several esteemed organizations, including the Cement Corporation of India Limited, Dedicated Freight Corridor Corporation of India, Sports Authority of India, Competition Commission of India, and the Bureau of Indian Standards. Advocate Sodhi Sir's legal expertise and dedication have been acknowledged in various judgments of the Supreme Court of India, where his work has been cited and recognized for its impact. Over the years, he has built a diverse and influential clientele ranging from prominent politicians to leading corporate entities. We are honored to have you here, Advocate Somir Sodi, sir, and we would like to invite you to throw some light on today's topic.
Good evening, everyone. My esteemed, very illustrious panel. And the problem with me now is that the first speaker amongst the panel has spoken so well, and I've seen so many of her students now are faculty members of this college. So it reminds me of cricket. And I hope the backbenchers here can come out of watching reels and just listen to me for 2 minutes. So in cricket, what happens is that if you're coming down as first down, which is the opening batsman gets out and you're the second one, there's a lot of pressure either way. If the opening batsman has done well, which in this case certainly has, you have to perform so that marginally you can reach somewhere where the opening batsman has. And if the opening batsman has not done well, even then the pressure is there. So please pardon if I miss out on something that I should have spoken about. Now, there is another problem that I see with our session. These people have been illegally confined since 10 o'clock in the morning. And I don't know how many of you all have gone out to have some... Yeah, they like that. Now that I have your attention, let me tell you, coming back to this city is lovely. Another reason why I accepted this was because I wanted to get out of the Delhi bad air quality. And I was looking forward to breathing some fresh air. I came here last night. And you know what the best part about human rights is? I exercised my human right here by looking at the stars. You can't see stars in Delhi, that's how bad it is. As I said, my target audience is going to be the backbenchers and possibly a few napping in the top first floor. I hope you can hear me and understand a little bit of what I'm going to say. Unfortunately, the topic for which I was chosen is something that I never understood in college. I'll tell you a reason. So international law used to be boring. We didn't have reels at that time, so of course we would just nap around in the class. And the reason was that, you know, if there is a violation, there has to be some sort of a sentence, some sort of punishment. And in international law as a concept, I could never understand sanctions. I could never understand diplomacy. Which is why I used to ask my professor, I was quite a pain in my class, that this is not enough, you need something more. And they had no answer, honestly. So I hope somebody can, I still continue to be a student of law and I'm ready to learn if there is something better than sanctions and diplomacy that possibly works in international law. Now look at what is happening today. You have two wars going on, full-fledged wars. One is Russia-Ukraine, that's been going on now for about 2 years. And the other one is Israel, everybody knows that. The impact of this war, these wars, is such now that the other countries are starting to get involved. So where are we leading? What is it, and I ask myself this question, what is it that these international organizations have done? So they have now, I mean, the last news that I saw 2 days back was that US has permitted Ukraine to use some ballistic missiles and they've started using those missiles. So it's only aggravation of the current situation. Now, I'm setting the tone of what possibly the other speakers, either the previous one or the next ones, can enlighten you and me on what this topic is about. Now, in the video that we all saw and heard, there was a quote which was not quoted, and it was actually Martin Luther King, who had defined peace. And I will quote and read it out. He said, "Peace is not the absence of war, but the presence of justice." And I'll repeat this once. Peace is not the absence of war, but the presence of justice. There is no violence around you, that's not enough for peace. You must have justice in the state where you reside. This is what he envisioned, and this is what I believe peace is about. Can you have a situation where there is violation of fundamental right and still there is peace? No, you can't. they go hand in hand. That equilibrium has to be always maintained in order to have sort of balance in the world. So where justice will prevail, human dignity will be upheld. We tend to use the word justice a lot. When you get into active practice, trust me, your clients will come to you, they'll tell you we want justice and you will have no answer. Because ultimately you are left to the mercy of the judge. So the judge does the justice, we as lawyers only can do whatever limited ability we have for our clients. Now, having talked about peace, I think human rights was very beautifully described by my previous speaker. And the different kinds of human rights was a good refreshment of what I failed to study in college. But let me tell you that human rights is something that is very, very much a part of our Indian culture. Vasudeva Kundabakam, which see the world as one family. Then you have Sarve Bhavantu Sukhina, let peace and happiness descend on all. So this is not something that is alien to our civilization. It was very much there. Of course, we now are trying to preach our way of life to the entire Western world, and I hope we succeed someday. There are different kinds of human rights which was already spoken about. What is the connection now between peace and human rights? As I said earlier, if you have a situation where there is no peace, there will be violation of human rights and vice versa. If your human rights are being violated, there is no peace. Let me now give you an example of how law and peace and human rights are maintained as per Indian Constitution. Again, a subject that I used to hate in college, but I love it now. So Constitution is a beautiful document. And with experience, what I've learned is that it sets the tone right for the state. For instance, a state, or when I say state, I mean the government, the police officers, the bureaucrats, the executive, legislature, they are only as per our constitution allowed to do what is written in the constitution. We as citizens can do anything under the sun unless it is prohibited by law. So there's a big difference. I have 100 things that I can do unless it is punished by law, unless it is prohibited by law. And on the other hand, the state can only do what they are permitted to do. So that beautiful balance is created in our constitution. And this beautiful balance brings in law, it brings in human rights because it tells us that you can do anything that you want to do. And it keeps the state in its place. So that's the relation between constitutional law, that's the relation between how constitutional law covers peace, human rights, and law in itself. Talking about reels, social media now has a great impact on, I feel, human rights in today's world. I mean, how many of you have seen, just by a raise of hand, those who are listening, those who are sleeping, it's okay. How many of you all have seen change.org as an organization? There are petitions that they move online, yeah? So that's, I feel, a very, very big movement where the marginalized have a voice. They will go to a small village in some part of the world and they will talk about that, they will sensitize people about it. That is the power of social media. So human rights violation can be put in front of the world only by click of the button. That's how important it is, I feel. Corporates today don't want to be on the wrong side of human rights. They are so particular. We were just having a discussion about the recent news. I don't want to take the name, but a big Indian corporate has now come into the news again. Any part of the world something like this happens, there is a direct impact on the market. You don't want to be seen by your investors as somebody who, let's say, enters into practices like bonded labor, child labor. You don't have a decent work culture in your office. All these are, I think, important now, especially in the age of social media. One disgruntled employee can put your market capitalization down by 10% by making a video and putting it on Facebook. Judiciary, I feel, has again played a very, very important role. Initially, there was a concept of only a writ petition that could be filed. with time. We have PILs, which are so integral in our entire system. I mean, I've seen bizarre cases in Supreme Court. I mean, I still feel it is not our court's duty to run businesses, but they take over companies, they appoint retired judges to take over trusts, to take over, for example, at one point of time, BCCI, I mean, as a cricket organization, it was taken over by Supreme Court and being headed by a former Supreme Court judge. All of this happens because of our wide powers which are given under the Constitution and the relaxation of writ petition by introducing public interest litigation by allowing somebody else to represent somebody else's cause and come in the front, which also indirectly and directly affects human rights. Now, this is going to be a little interesting. Can laws, which we hear of every day, violate human rights? Laws are supposed to protect our rights, but can they violate human rights? And I'll give you an example. Innocence till proven guilty is what we see in all our series and what we read in college. But in India, we have two fantastic legislations, and I'll open it for any one of you to guess, where when you go to the court, it is written in that law that you have to prove that you are innocent to get bail. That's the kind of regressive law that exists. It was set aside by the Supreme Court once that no, you can't have a situation where I have to prove my innocence because the burden is always on the state to prove me as guilty before getting bail. So that's anyways PMLA, UAPA, these are the laws that are still there on the book. Supreme Court set aside section 45 of PMLA, and later on that judgment by Justice Nariman was overturned by Justice Kanvilkar, and that's the law of the land currently. There is another, I talked about Russia, Ukraine, Israel, Gaza. Another violation that we saw of human rights was Manipur. I mean, just look at what is happening in that state and the utter failure of the authorities to do anything about it. I think it's miserable. Courts have to, of course, step in, put their foot down, ask the authorities what they've done. And it continues to be a state which can be a prime example of violation of human rights. Explicitly, I mean, we saw the kind of videos which had gone viral. Therefore, it is important to control law and order within the country, and the same thing can happen at a global level as well. I want to ask one thing, and I hope I am corrected maybe. If sanctions and diplomacy is not enough to ensure that global peace is maintained, what else can be done? Because I initially started off by saying that I don't understand this subject. And I was thinking about it, that what better can you do? So I feel today the whole world is about money and power. You incentivize maintaining peace. You incentivize maintaining human rights to different states. So as United Nations, for example, if you come out with a policy that if some country scores 100 out of 100 on this scale that we are going to judge you on, we are ensuring you that our members are going to put in sovereign funds, they are going to invest in your country, you get a better seat at the table. I'm sure we can do something, provided we start to incentivize, because according to me, sanctions and diplomacy have completely failed. I hope this session was not as boring as the previous one, if I may say so, if you found it boring. But yes, thank you very much. You all are wonderful, and all the best to you.
Thank you so much, sir, to share your insightful thoughts with us today.
Next on the dais, we have Advocate Rachana Reddy ma'am. It is both an honor and a privilege to introduce a legal professional whose exceptional work has not only shaped the field of law, but also contributed significantly to the cause of human rights and justice. Ma'am's career is a testament to excellence in advocacy, legal education, and social justice. Since 2005, she has been a formidable presence in the Andhra Pradesh and Telangana High Courts, specializing in corporate, civil, and criminal law. Her expertise in international and comparative law honed through her LLM from UCLA. positions her as a thought leader in areas ranging from international business transactions to intellectual property and human rights. Beyond her practice, ma'am has dedicated herself to shaping the next generation of legal minds as an assistant professor at Nalsar University of Law. Her academic contributions also extend internationally, having worked as a foreign attorney in the US, focusing on asylum and immigration cases. Her contributions to legal scholarship are equally impressive, with numerous published papers on international trade and women's rights. Ma'am's work has earned her accolades, including the Vocational Excellence Award and the Nyayashri Award, recognizing her exemplary work both in the legal field and in the pursuit of justice. Please put your hands together and join me in welcoming Advocate Rachana Reddy ma'am to share her insights with us today.
A very warm good evening to everyone here, and I'm glad you all are woken up again. And I hope I can make this 8 to 10 minutes as interesting as my previous guests. One was very theoretical, which you all absolutely require, and the other was what it is. I mean, it was fun. So I hope I can try to be a little bit of both and definitely bring in another ingredient that is controversy. Today, I mean, my, and I thank the student, or rather the narrator, who's read out all about my accolades, etc. Well, I'll start out with my absolute first case that I did when I was working in the US. That was an asylum case, trying to get an asylum for a beautiful, beautiful gay man from Mexico into the United States, who was subjected to repeated rapes to transform his mind, apparently, by his family as well as, the extended whatever. So my tryst with human rights started in a very traumatic way. I mean, because as a 20-something in the US and your first case is that, it's another level of trauma for at least a couple of months. But what it taught me also is how to not judge or segregate society into a good or a bad. We are all gray. We are all shamelessly gray. And that also brought about the concept of understanding why something is happening, which in my opinion was bad, ugly, gruesome, brutal, etc., all the synonyms. And then slowly, at this point of time, I'm starting with my first traumatic asylum interviewee experience, who finally ended up getting asylum in the US, to what my previous speaker just spoke about. What if sanctions and diplomacy doesn't work? This is where I have come to the other side, the absolute other side of human rights, the absolute other side of peace, and probably where, in my view, I will venture into the controversial. Today, I would like to talk about a concept which is Western, but which is very much practiced by us as well in India, has been practiced for generations and centuries, but not really accepted or acknowledged, I will say, not accepted, but acknowledged in our academic books. That is peace through strength. Peace through strength is, yes, I'm sure whoever has been following the American elections, or has anyone been following the American elections at any point of time? Yes, some of them. I was very interested. I watched it until the very last, until the absolute rout of the Democratic Party and everything. So I'm sure you'll have heard at least, the few times that you'll have seen, how they stand on issues about the concept of peace through strength. Now, peace through strength is a rather nice sounding word for the fact that this peace can be achieved only with a sort of Damocles or some kind of a threat or some kind of a pervasive higher power hanging over something which, in case, if not for that power, there would not be any peace. So, peace through strength is something that came about prior to World War II, but it has been a part of the American evolution, the American Civil War to where they are today. And it started out all with George Washington, and it has been popularized by Ronald Reagan, and of course, Donald Trump trumps it a lot. So peace through strength is what I would like to focus on a little bit and try to apply it to the present conflicts and to the conflicts and the manner in which we have also addressed certain conflicts in India. So why do you think there is this disarray, or rather this scramble to bring about some kind of a solution for the Ukraine-Russia war, the scramble to bring about a solution for the Israel-Gaza war, or the scramble in China to behave itself? Because it is, right? I mean, at least in the last 1 month or 3 weeks, China is behaving itself, or at least it's trying its best to behave itself. So why do you think is this? I mean, anybody, I'm trying to make it interactive. Wild guess, soft guess, some guess. Internationally, I mean, there's been, so I guess you all don't follow international politics too much then. Well, this scramble with China trying to behave itself in the Pacific Ocean and trying to be good to India, taking back its troops at the borders, at the LAC, the Israel-Gaza war somewhat trying to wind itself down, the Russia-Ukraine war trying to wind itself down is because of some, yes, he might be crazy, Donald Trump, but the fact that his foreign policy, at least as far as peace is concerned, the one aspect of peace in human rights is concerned, is peace through strength. This man, right back in 2017 during his 4 years tenure to now, and I will talk about how it's applicable to India as well, has brought about peace in conflicts and tried to restore. See, when peace is brought about in conflicts, the restoration of human rights becomes an automatic after effect of that. Now, this bringing about peace, if it is not possible through diplomacy, through soft talk, through talking again and again, through trying to give and take, to barter, etc., then you try to threaten. You try to say, this is what will happen to you if this is not done. Yes, probably not a part of our topic of human rights, which is all about doves flying, which was flying right now in your introductory reel. Because human rights and peace is really not all white and flowery and fluffy, and it's not really all about doves. It does take a lot of courage. It does take a lot of putting your foot down, and I mean countries. And it does take a lot of overt and covert pressure to see that peace is brought about in any way, hook, crook, and any ways in between. And that is where, and that is when the glimmer of human rights, because human rights necessarily can only operate when there is peace. And if that peace itself is absent, as you have seen in the Gaza war or in the Russian-Ukraine war, if that peace itself is absent, then human rights and the violation of human rights, or women, children, this and that, and you have 30,000 today and 40,000 tomorrow, it becomes just numbers. I mean, human lives become just numbers. So, are we going to be following peace through strength? Yes, we already have exhibited the fact that we are following peace through strength in the recent conflicts as well. Your Uri, your Balakot, we responded right back. Do you think it's required? Should we have responded right back in 1971? I'm not going to talk about history. Maybe we should have. I'm not going to get into that. But the fact remains that the way to contain an enemy is not just through diplomacy, is not just through the very overt way of trying to reason with reasonable powers, but to realize that in this world, for human rights to prosper and for peace to return, you need to deal with rogue countries. And the manner to deal with rogue countries is peace through strength. You need to threaten, you need to blackmail, you need to do whatever it takes, and probably the synonyms I should not be using in Human Rights and Peace Conference, and I apologize for the same, but then that is the real fact of international polity. Therefore, peace through strength. I'll just wrap up with reading what George Washington spoke about, quoted about it. It's actually a Roman concept. George Washington said, "There is a rank due to the United States among nations which will be withheld, if not absolutely lost, by the reputation of weakness. If we desire to avoid insult, we must be able to repel it. If we desire to secure peace, one of the most powerful instruments of our rising prosperity, it must be known that we at all times are ready to go to war." Therefore, my angle to this human rights and peace is that, yes, human rights, peace, global non-conflict, everything works. But that everything, in some cases, and at least in most cases in recent times, we've seen it work only through strength. Thank you very much.
Thank you so much, ma'am. Your thoughts and insights have truly added value to our discussion.
Moving forward with the panel discussion, it is both my honor and privilege to invite Advocate Prateek Rajopadhyay, Managing Director, Managing Partner of Tavish Law Associates, an accomplished legal professional with a distinguished career that spans corporate litigation, financial fraud, and due diligence. With a proven track record of handling high-profile cases, he brings a wealth of experience in corporate law, having successfully navigated complex legal challenges across various domains. Some of his notable achievements also include representing a prominent non-banking financial company in minimizing non-performing assets, demonstrating his expertise in financial legal frameworks, advocating for a renowned German company in a multi-jurisdictional investment fraud case, showcasing his strengths and skills in cross-border litigation, also conducting legal due diligence for a major resort group seeking funding from a leading Japanese bank, reflecting his strong acumen in corporate financing. Advocate Rajopadhyay's sir's area of expertise also extend to commercial disputes, real estate, arbitration, private defense, and environmental law. He has represented public listed companies, private limited companies, and statutory bodies in a variety of significant matters. Furthermore, Advocate Rajopadhyay Sir was a part of the counsel in the landmark case of Justice K.S. Puttaswamy versus Union of India 2017, which redefined India's legal framework on the fundamental right to privacy. We are truly privileged to have you with us today, sir, and would like to invite you to address the gathering further.
First of all, I would like to thank MIT for having me here. Honestly speaking, I feel like I'm a pinch hitter, taking forward the same analogy as Mr. Sodhi, that he came one down to bat and I'm the last person probably to bat and I have to score some runs before we are off for the day. So I very well understand that I'm standing between your freedom. So I'll not take much of your time. Most of the issues, most of the topics have been covered by my learned predecessors. So I'll just thank them for letting me speak on one topic which I had actually prepared for, and they have not touched upon that topic. So I'll really extend warm thanks to them. So today I would like to speak on one important aspect that probably all of you are unaware of, or maybe you're aware of, but you do not realize the harm that it possesses. How many of you have mobile phones? All of you. What is a mobile? What is it? It's a device, it's an electronic device. Ultimately, it's a technology, right? So, I want you to answer whether technology is a boon or a bane in protection of human rights. It's a bane. I have heard somebody say bane. Why so? Whether it's a boon or a bane, come on. It's a bane, okay. So please tell me why. Any one of you, come on. It's an open session, so I want all of us to have a dialogue so that we can all promote peace and human rights. So, why do you say it's a bane? What makes you say that it's a bane? Privacy is violating, that's correct. What else? Any recent examples where technology was used to perpetrate certain crimes, certain surveillance? Okay, digital harassment is what I hear from you. How many of you are aware that a few months ago, this is again allegedly, Israel conducted a surgical strike of sorts on various Hamas leaders? Are you aware of that? Okay. What was the device used? Pagers. So Israel apparently got into the system of the manufacturers of those pagers and they initiated those initiated blasts using that system. So how many of you think that this is a violation of human right? Okay, I can see a couple of hands there. What about others? You don't have an opinion? Come on, you're lawyers. All lawyers have opinions. So how many of you think that it was a violation of human right? None of you. Okay, those who are raising their hands, please, can you tell me why do you think it was a violation of human right? You don't have to be anonymous, it's okay. We are all here to make mistakes, we are all here to have a dialogue, so it's okay. You can stand up and answer. Sorry? People were killed. Okay, so you think that was a violation of human right? Okay. What about others? Those who are saying that it was the right thing to do. Why do you say so? Anybody? Okay, so since you guys are not answering that question, I believe that although the intent was to neutralize the threats to the sovereignty of Israel, I believe that this was a violation of human rights to an extent where certain privacy was breached, certain systems were hacked. Now again, this is my individual opinion and everybody is allowed to have their own opinions. Now when we compare the same situation with different wars that are going around in the world. For example, Mr. Sodhi just mentioned about Israel and Palestine, then we have Syria, then we have Ukraine and Russia. All of these conflicts, they have a certain edge of technology, and the person having a superior technology is always going to prevail. Now, to summarize this particular topic, now I've got some points written here, so please excuse me for a minute. Yeah. So, while we have discussed elaborately that how this is a bane, there are certain aspects which also help in preventing human rights violation. First of all, information gathering. With the advent of resort to spreading awareness using technology. Now, at the same time, the same government also decides to shut down internet in those parts of the world. So, it's a tool in the hand of the government to decide whether to use it as a positive method or a negative method. So, most of the governments use technology as a tool to raise awareness on human rights violations. Then it is also used for online campaigning, as one of my learned predecessors mentioned about change.org. So that is again a tool in the hands of people to voice their opinion and to raise blatant violations of human rights. It is also, technology is also used to secure communication. Now, there are areas where communication has become an issue because of war, because of crumbling infrastructure. Now, that is where technology comes in handy, where it's much easier to disseminate information and raise awareness. Then, there are certain applications, I don't know how many of you are aware of that, but there are certain applications which help in digital collection of evidence. So, if you're witness to certain human rights violations, there are applications which you can use to record a violation, and then it is forwarded to the law enforcement agencies of that respective countries to help in investigating those violations of human rights. Then use of artificial intelligence as well. Now we have a lot of advent in technology where artificial intelligence is used to identify certain early warning signs of a brewing unrest, of a brewing civil war, because most of these non-state actors, if I may say so, who indulge in such war crimes have a certain way of communication. Now, to give you a very recent example, Boko Haram used to communicate through social media, and then government realized, the law enforcement agencies realized that Boko Haram is using their social media to communicate with each other. Then they started monitoring that, and that is how most of their leaders were killed. Most of the terrorists of Boko Haram were killed. Now, this is one such example. There are many other such examples you'll find where technology has been used to curtail certain unfortunate, untoward incidences, have helped in mitigating certain human rights violations, have helped in spreading awareness. So now that brings me to the closing of my topic for the day. I believe there is a lot of work to do in this particular area, considering that all of you have mobile phones. Almost every citizen, wherever he is using technology in some way or the other, be it mobiles, be it laptops, be it any other communication device. So it's necessary for all of us to work coherently to ensure that we are not allowing this particular device, this particular tool, to be used as a tool for mass surveillance or to collect private data allow breach of privacy. So I think it's a collective responsibility of ours as future lawyers to ensure that we keep our vigil high and we ensure that such incidences do not occur. So with that, I will stop for the day. Thank you so much for having me here. Thank you once again.
Thank you so much, sir, for your knowledgeable and valuable thoughts and insights.
We have now arrived at the end of this session, the resolution. In the light of the speeches by our panel members and discussions carried out today, I shall now read out a resolution. I would request everyone to stand up and raise your hands for the resolution. We, the participants of 4th edition of International Symposium on Law and Peace, hereby affirm that we shall recognize the universal importance of human rights as the foundation of global peace and resilience, and for collective action to address systematic inequalities, foster inclusive development, and promote justice and equity for all. Kindly respond by saying, I affirm. Thank you, audience. Kindly take your respective seats.
As we come to the conclusion of this enriching session, it is now time to express our gratitude to all those who made this event a success. To deliver the vote of thanks, I am delighted to invite Dr. Dhanashri Tharkude ma'am, Dean of External Relations at MIT World Peace University's Ramcharan School of Leadership, to the stage.
I would request everyone to settle down kindly.
Good evening, everyone. Good evening, everyone. As per the culture, I am aware that we generally start thanking the guest first, but I heard you were trying to clap for yourself before. So please continue that. So thank you so much for being here. I broke the protocol. I apologize for that. On behalf of Dr. Vishwanath Karad, my MIT World Peace University, I, Dr. Dhanashri Tharkude, would like to propose vote of thanks. I'm really very honored to be a part of this particular session. I congratulate Dr. Purnima Inamdar and the team for organizing such a wonderful event and inviting other institutions also, like I'm one of the, from the management part of it, MBA and BBA, for inviting for such important events. Thank you so much. I would like to start with Dr. Ujjwala Bendale, madam, for setting the tone on the concept of human rights and describing the term equality and dignity. Thank you so very much. You very beautifully explained that. Next, Advocate Sumir Sodhi, sir, Advocate on Record, Supreme Court of India. So thank you for highlighting the meaning of peace, underlining the impact of social media on human rights with plenty relevant examples. We really thank you for that. Advocate Rachana Reddy, madam, Senior Advocate, sharing your personal experiences, US experience, international politics, and it was really a great blend of theory and practical world. Thank you. Advocate Prateep Rajopadhyay, sir, Managing Partner, Tanish Law Office. Thank you so very much for highlighting the importance of technology and keeping the session interactive and informative. Thank you very much. Thank you very much, audience. Thank you, everyone.
Now I request the technical team to play the national anthem. We all raise for the same.
Jana Gana Mana
Bharat Mata ki.
Dear students, tomorrow we have our other sessions and the valedictory. Your registration decks for the attendance will be open from 9:45 and it will be open till 10 a.m. So you all have to report in the auditorium by 10 a.m. positively. Apart from that, please meet your class teacher as the designated place which has been given in the official WhatsApp for the attendance. Thank you. Students, I am again repeating, tomorrow the registration